when you judge it against everyone in the house, he's the only one with the Rambo story. Has what Kellsey says.
For sure.
He walks into a suicide in progress. He sees it.
Welcome,
he reacts.
welcome,
Kellsey,
welcome.
no.
Everybody
Kellsey,
on
no.
YouTube, welcome,
Bam,
welcome,
bam.
welcome. I apologize. We started a little
Brain
late, but
freeze.
it's okay.
Mistake. Has to cover
It's
it up
okay.
immediately. What else do we have? You know, when you're a fact finder, Your Honor, you know, you want to look for corroboration. What's the corroboration on either side of this thing? Or lack of corroboration, which is what really it is here. You know, the big one, the big elephant in the room is that this department has no body cameras.
Keep real. I think I'm about to start shaking and baking on
they
cake,
had body
man.
cameras. There's no evidence other than people's words. He said versus she said. That's oftentimes, almost all the time, not a good place to start for the Commonwealth.
All family pharmacy. Getting a prescription doesn't have to be such a hassle.
What's up with that? Why didn't Trooper Strong put the body camera video on the witness he's interviewing?
Oh.
There's no science.
Might have got something with that body cam. Might have.
The testimony of everyone
Said
in
he did it,
else
but he
in the
did
house
it.
shatters his narrative. Kellsey Fitzsimmons has been blessed. She should be dead 2 times over. By her own hand.
2 times, not once, but twice.
By the hand of Officer Noonan, who shot too quick. She's blessed. She's here today, and she has a new lease on life. And maybe that's why the investigation is what it is. And maybe that's why Noonan's story is so sloppy, because nobody expected her to be here today, to tell her truth. But she is, Your Honor. And as the fact finder, I want to respectfully ask you to consider the evidence, consider the lack of motive, the lack of intent, the inconsistencies. The credibility contest is firmly in her camp. She came in here and she told you what happened. Unvarnished truth. And I ask you to find her not guilty. Thank you, Your Honor. Thank you.
Yeah.
I may?
Yes.
Every piece of credible evidence in this case proves one thing, that she's guilty. All the testimony, the scientific evidence, the physical evidence,
Fire.
the demonstrative evidence, everything points to one conclusion: she is guilty. Even her own testimony proves she's guilty. Because it's impossible to have happened the way she said it. It is scientifically, mechanically impossible for it to happen the way she said it.
Dang.
Her story
Thinks it
is
scientifically and mechanically.
that she grabbed a gun, put it to her head, pulled the trigger, and it clicked. The chamber was empty. That's what her story is. And that's what Officer Noonan's story is, too.
Oh, she ain't had one up top
Pulled the trigger,
game?
clicked,
She ain't had her.
nothing came out. There wasn't a round in the chamber. She even said, she told everybody how stupid I am. I tried to kill myself with an empty gun. But what do we know about the gun? What do we know about her gun? Because after she went to the floor, Lieutenant Davey picked it up, put it on the bed. Officer Noonan picked it up and put it on the table. And then Officer Kaur came in the room. And what happened then? Officer Noonan said, secure that gun, make it safe. And so what did he do? He took the gun, he found that black box, the safe. He made sure that was empty. He turned it over. He pulled out the magazine that you can see right here. He opened the chamber, and there was a round in the chamber. He dumped it out into this safe and put the firearm in there. And then they stood watch on that until State Trooper Bonasara took it back in the lab. That magazine that you have in evidence contains 16 rounds. It was a 17-round capacity gun.
16?
It contained 16 rounds, plus the one that was in the chamber. 17 rounds. As we know, there are only 2 ways to get a bullet into the chamber. One is if there's already a bullet in the chamber, someone pulls the trigger, a bullet comes out, the casing comes out, the chamber's open, the spring allows another bullet to come up. That's one way, and we know that didn't happen here. The gun didn't fire because the chamber was empty. The only way a bullet gets in this chamber, other than that way, is if someone racks the gun. She said she didn't rack the gun, but there was a bullet in the chamber. She did rack the gun. What did Officer Noonan say? She pulled the trigger. Nothing happened. She stepped back, tap racked, tried
hearing
again,
that click,
didn't
boy,
do it.
that shit.
Tap racked again.
That click.
pulled it.
That was that. Boy, that shit brought back
That's
memories.
what
You hear me?
She put a round in that chamber.
Respectfully.
That's
Shit.
the only way it got there.
Shit just sent chills through my
Her
body.
story
It's like,
can't be true. She got up on that stand and she lied to you. It's scientifically and physically impossible for her story to
Nigga
have
called her a
happened
liar.
like she said. That's what the
He
evidence
called her
shows.
a liar, bro, in court.
But she didn't just lie to you then. She lied again. She lied at the scene about where the guns were. And I'm not, and she admitted that, and I understand that, right? And she said she lied to the police because she decided to kill herself. But when did she say she said that? They had been to the house. They had talked to her, according to her. She now started contemplating all of the ramifications of what's going to happen to her. Because she's losing her life, her job, her son is being taken away, all of these things. And so she's going that over her head. And then minutes later, as she's walking through the house, she says, my gun's in the basement. Because that's the time she made the decision to kill herself. Later on. And we know that's a lie. We know that's a lie because what was one of the first things they asked her when they went to that house? They asked her to put the baby down because they were concerned for the baby, told her of the restraining order, what the parameters were, and asked where your guns are. When she was still sitting on the
They must have
sofa.
just turned the noise suppression on because that shit just got loud.
They weren't waiting to ask that question so she was already walking around the house. No way. And what did she say there? They're in the basement. And we know she said it there before she moved around the house, which is untrue. Because her friend, Officer Houston, who was invited to her wedding, says it also. He says, Sergeant Daly asked. And then remember what he said? he said, I was in the living room, she was sitting down, and then I saw a gun case on the other sofa. And so I opened it up to see. And she said again, I already told you the guns are in the basement. Now, why at that point did she say that? We don't know. She didn't tell us, because she lied to us about why she said it later, because we know she didn't say it later. So she lied again. You can't trust her. She also lied about knowing that her mom was in the house. She was upstairs. The officers, Noonan, I think it was, Noonan heard an older woman's voice down there and said, who is that? She says, I have no idea. She doesn't know her own mother's voice, her best friend that she just talked to come to the house. And she said she didn't know whose voice it was. Another lie. She said on the stand yesterday that she didn't know Justin was in the house. And we know that's a lie too, because what happened when the three of them were upstairs? It's Noonan, it's Houston, and it's the defendant. She hears him downstairs. Houston hears him downstairs, and she says, keep him away from me. I don't want him in my house, or something to that effect. And that's when Houston went down to make sure he wasn't coming up and went to the basement. She knew he was in the house.
She definitely said, I don't want him in the house.
She absolutely did, and she lied to you when she said she didn't yesterday. And you know what else she lied about? Something so simple, but it shows who she is. The restraining order. She said, the restraining order was taking my dog away. It says it. It doesn't say that. Nothing about the dog in there. I could go on about the lies, but I want to talk about the credible evidence. The credible evidence in this case. When Lieutenant Daly got a call,
Not looking too happy.
I actually got a visit from Justin Elaine.
Not looking too
He was
happy,
in the lobby of
jeez.
the PD. And Justin told him he got a 209A against Kellsey Fitzsimmons. And Detective Daly knew that she had been sectioned before, that she had guns, that they were taking the child away from her for a period of time. And so what did he do? He called Officer Houston. He asked Houston to call Daly to meet up. And why did he say he did that? He said because those two are cool, calm, and collected. They don't panic. They keep things calm. That's what he said. And that's why when he called Houston, he said, can you call Daly, we got to do this. And so he wants you to believe, defense counsel, that Pat Noonan was cavalier about, oh, okay, sounds good, we have to serve a restraining order. But that's not what happened. He was mischaracterizing it, I hope you remember, in the grand jury minutes, because Houston had called Pat and said, hey, we got to serve an order, can you meet me by the school? And Pat said, sounds good. It wasn't until he got over there, it wasn't until Lieutenant Daly was there that they learned really what they were going to do. And they went over there. And defense counsel asked Daly, you guys were cavalier about it, you knew her, weren't worried about the guns, all this stuff. And Lieutenant Daly said, no. No. His quote was, we had an increased level of diligence. Everyone was more on point because they did know what they were walking into. They did know. They did know that she had been sectioned before. They did know there was going to be a baby in the house. They did know that she had guns. They did know at that point that she had parked her car far away. This is all going to what they were thinking at that point. They did know all those things. And they did know Justin's concerns. He said, according to Lieutenant Daly, I'm worried she's going to kill the baby, kill herself, and kill someone else. So that's what they were thinking when they went into this house. That's the credible evidence when they went in there. And what did they do when they went in there? They sat her down, and they allowed her, or maybe they asked her, I can't remember, to go around and get some stuff for the baby because she knew Justin was coming to get the baby. And they were in her pocket the whole time. They followed her around the house, at least 2 of them, while she did that. And you know that because even Officer Houston said, I was in her pocket. We went into the kitchen, and I noticed there were butcher blocks with knives on it, with knives in it. And they were concerned. There was no chance they were leaving her alone. No chance they were leaving her alone. Officer Newman. Officer Newman. All of the testimony that you've heard about Officer Newman, even from the defendant, he's a gentleman, he's experienced, he is by the book, and his training and experience starting in the military, through boot camp, through security forces school, security forces squadron, with all the training he had, and Humvees and helicopters, and the SWAT team, 2 times a month training, clearing rooms, clearing buildings, hostage situations, missing persons, shoot, no shoot scenarios, twice a month, and a 40-hour block every year. For over a decade he did that. And he moved to Lawrence, as far as the department goes, because it was busier, and he had more experience. He was cool, calm, and collected. There's no doubt about that. And to say when they're upstairs and he walks away and leaves her alone because he heard a commotion that Officer Houston was going to attend to is a joke. It really is. Now, how do you know they were going by the book at that point? And how do you know they were vigilant? Because they followed around everywhere. Because both Houston and Officer Noonan said she kept handing us things, and we kept putting them down. We wanted our hands free. Because they were ready for whatever happened. Hoping nothing did, but ready for whatever happened. So at some point, Houston and Noonan are upstairs, and the defendant goes into her room. And she hears Justin. And Houston goes down to keep the peace to make sure he's there. And Officer Noonan is watching her. He's watching her. And she's on one knee. And she lunges, and she disappears. And she emerges with this, pointing at him like she is trained to do. Click at his face. And what does he see next? He draws his weapon, and he says, his testimony, it kind of slowed down. The whole thing took maybe 4 seconds, maybe even 3.5 seconds. His training has kicked in. His experience has kicked in. It was a surprise to him, certainly, because she got the drop on him. And why did she do this? Who knows? Maybe he's right. Maybe she was going through him to get to justice. Maybe she was just so upset she was going to shoot anybody in front of her. Maybe she wanted him to shoot her. We don't know because she lied about it. We don't know. But the fact is, she started to shake, she started to tremble, and she lunged for the gun that he couldn't see. And what happened after she clicked? She stepped back, and now he knows, based on his training experience and the click, there is not a round in the chamber. He knows that, and so he doesn't shoot. According to the defendant's testimony, he had every right to shoot at that point. And you know what? He actually did. He had a right to shoot her at that point. If you point a gun at a cop and pull the trigger, they get to shoot. But he didn't. Because he was controlled and disciplined. That's the way his career went. And so she steps back, tap, crack, and tries to do it. He doesn't shoot her then. And what's he doing at this point? Kellsey, no. Kellsey, no. Because he knows the threat isn't there, really, because there still wasn't one in the chamber. Kellsey, no. Kellsey, no. He is being disciplined like we wish every police officer, every law enforcement agent in this country was. He should be applauded for his actions on that day. Tap rack again. Now he knows one's in the chamber. Threat's on. She starts to raise it, and he shoots. He shoots twice to stop the threat. He stopped shooting when the threat was neutralized. Defense counsel, during his cross-examination, well, you would have unloaded her gun. He goes, no, that's not what you do. You shoot until the threat is neutralized. She was now down on the ground. But his training and experience are still taking over at this point, because what does he do? He still has his gun on her, because the gun's still there. He can't see it. Lieutenant Daly comes in, Lieutenant Houston comes up, and what does Officer Houston say that he sees when he comes upstairs? That Officer Noonan is standing there with the gun low and ready. His training is still taking place. He's still doing what he was trained to do. The gun is put on the bed. He's calm and collected. He takes the gun and moves it away so people are safe. He's deliberate in those actions. When it's away from her, he starts to tend to her. Officer Core comes in, and he asks Officer Core to make the gun safe. He's cool, calm, and collected. That's what Lieutenant Daly expected, and that's what he was. He didn't make a mistake. That's what the credible evidence shows. And what did he say to Officer Houston after? And this just goes to state of mind, I know. That she pointed the gun at me, and it clicked. And she tried to rack him up. Immediately after. This wasn't him saving his hide or protecting himself. Seconds after this happened, that's what he said. Every piece of credible evidence points to the unmistakable fact that she is guilty. Every piece of physical evidence, scientific evidence, mechanical evidence, every piece of testimony from Daly to Houston to Core, even Lauren Page, the mother, even the defendant corroborates what Officer Newman says. Every piece. Your Honor, I would suggest to you there is only one fair and just verdict in this case, and that is guilty. Thank you.
Maybe for a sidebar.
I'd like to speak to counsel anyway at sidebar for scheduling purposes. I'm just going to, we went to sidebar for two reasons. One was Mr. Bradle has a series of objections that he'd like to lodge about the Commonwealth's closing, which I'm going to give you an opportunity to do in open court with the Commonwealth in open court responding. And also I went over the schedule. So as I told counsel, my intention is to take as long of a period of time as I need to reach a verdict, provide the court staff and counsel with 30 minutes notice, and come out and announce my verdict. some of my reasoning here in public, and whatever time that works. In other words, if it's during our traditional lunch break, so be it. You folks will have a half-hour notice, which means that you'll be able to go and have coffee or lunch or whatever, as long as you can get back here. All right, so that's how we've worked that out. We also discussed at sidebar the fact that in a jury trial, we never provide the jurors with ammunition and a firearm, even with a trigger block at the same time. So my intention is that Mr. Ruane, our assistant clerk, will keep possession of the ammunition, and the firearm will come back in chambers with me along with the other exhibits. When and if I need the ammunition, they'll be switched out. All right. Okay. Globally, have I discussed have I said in open court what we discussed?
Yes.
Okay. All right. So, Mr. Bradel, I'll hear you on the objections.
Thank you, Your Honor. So, Judge, traditionally we do this at sidebar, but as you mentioned, we don't have a fact finder here that we need to talk off to the side to. So, in open court, I'm happy to do this. Sure. Yep, I'll go back over everything I said at sidebar, Your Honor. Judge, the first objections I have to counsel's closing argument center on ballistics issues. The first part is that counsel picked up the gun and used it 3 times. Prior to that, counsel provided what I would consider to be expert testimony on the operation of the gun. I think it exceeded the scope of what Detective Bonasaro talked about. He said that it had to be a scientific certainty that this gun was racked by Kellsey Fitzsimmons. He mischaracterizes the defense position that we're not saying necessarily that it did or didn't happen. We said that Kellsey Fitzsimmons didn't rack the firearm. And we have a completely different version of events. So no one's saying that it didn't happen. We're saying that Kellsey didn't do it. And to characterize it like, you know, that it had to be racked by Kellsey Fitzsimmons is not fair argument, and it mischaracterizes the state of the evidence. The second objection relative to ballistics, Your Honor, is that counsel was acting out. I believe it was the second time he picked up the firearm. Counsel was acting out on Noonan's story that Ms. Fitzsimmons had accessed the firearm from the chest and picked it up to point it at Noonan's face. And on Noonan's testimony, she just pulled the trigger and it clicked. Counsel's acting it out. Prior to pulling the trigger, counsel racked the firearm and then pulled the trigger. And that's not what happened on even Noonan's testimony.
I'm happy to allow you to make a record, but the fact that there's 2 different versions of what folks testified about is fair game. What the issue right now is whether the Commonwealth argued items that were not in evidence or attempted to draw inferences from items that were not in evidence. So the disagreement about the racking is just not before me.
Well, that's why I bring it up, though, Judge, because this racking issue has been brought up to the forefront, and he did something that is not part of the evidence. No one says that she racked the gun before the first shot, and that's what he did when he acted it out. So that's why it's a mischaracterization. I'll just rely on Your Honor's discretion.
But that's not what Mr. Gubitosi did, though.
I did see him rack the firearm before he fired the second shot. He did it the second time, Your Honor.
Okay, I'm having trouble understanding. Again,
it's just that when you act out the testimony, you have to do it accurately, and he didn't.
I'm going to say this in open court, and it won't be the last time I say it. Whether or not Officer Noonan exercised reasonable use of deadly force is not before me. That is not my decision.
I agree with you, and I say it on credibility.
And hold on. And whether the North Andover Police Department followed procedure in serving this restraining order is not before me. Child custody is not before me. All right, visitation is not before me. What's before me is, has the Commonwealth proved beyond a reasonable doubt that the defendant pointed that firearm for any perceptible amount of time at Officer Noonan? Okay, so all of this is just not helpful.
And I offer it on credibility, though, Your Honor.
Okay.
Also, the Commonwealth said that on the scene, Ms. Fitzsimmons didn't say part of her story there, so therefore she's making it up. And whenever the Commonwealth tries to argue that somebody, a defendant, didn't say something, that's very dangerous ground for the Commonwealth, Your Honor, that the defendant is under no burden whatsoever to say anything, Your Honor. And here, to suggest that she's lying because she didn't say part of her story when she's shot in the chest at the scene is unfair argument, but it also violates her right to remain silent. And it's an intrusion on that, so I would object to that. I ask you not to consider that, Your Honor.
Okay, except that, Mr. Bradel, she waived her right to remain silent, right? She testified, so.
At the scene, though, Judge.
Isn't it fair game for the Commonwealth to discuss the testimony that your client offered?
The testimony, yes, but he's saying that at the scene, she didn't say XYZ when she didn't have to say XYZ at the scene. And that's, you know, the Commonwealth can only argue that when a defendant makes a comprehensive statement and leaves something out. To my client that she wanted to kill someone else, which didn't happen. That was not the statement. So that's a very important, very dangerous, very unfair, very prejudicial misrepresentation of what was attributed to Justin Elaine in the lobby. She never said anything about killing someone else. He didn't even he didn't say that she said that. So I ask you to strike that and not consider it. And the last thing, Judge, about lying about the dog on the restraining order, Your Honor, that trying to take her dog. And it is in the complaint to the restraining order by Justin Elaine.
I know he's trying to do a second closing, but the evidence is what the evidence is.
Yeah, but Judge, you can't say, when you have the discovery on the point, you can't say that something is a lie when you have the papers that show it's not a lie. And the box was checked in the complaint to get her dog. So that's a mischaracterization of the evidence that needs to be corrected, Your Honor. And that's my last point. Thank you.
So, Commonwealth, from my perspective, with all due respect to Mr. Bradel, who's done a terrific job advocating for his client, I view that as nothing more than a rebuttal to the Commonwealth's closing. So I'll give you a few minutes to rebut these things. Let me say this, though. I don't believe that there was any evidence before me that Miss Fitzsimmons was sectioned previously. I think that the way I view the evidence is that this is what the police believed. It was part of their state of mind in serving it. But I'm at a loss, frankly, that, in other words, what I'm saying, Mr. Bradel, is out of all the items that you argued about the Commonwealth purportedly arguing something not in evidence,
Yes,
this sectioning, alleged sectioning that happened prior to this,
yes.
there's no evidence of that before me. There's mention of it, and it goes to the officer's state of mind. So, and that's all that in fairness, that's all that you argued, Mr. Gubitosi. But I guess what I was getting at is if there was anything at all that came close, that would have been it. But Mr. Gubitosi, I'll give you a few minutes for your rebuttal to the rebuttal.
I don't think I need it. I trust you to have sifted through what's relevant, what's not relevant. The evidence is what the evidence is. Closings are not evidence. I would suggest to you that, I guess I do need to be heard, I guess. That I argued the evidence that came from the witness stand and from the exhibits Drew Ravanasaro absolutely described the ways that a firearm works and how a round gets into the chamber, and I limited my explanation of that to what he described and the like. I don't need to make a second closing. Thank you.
You just did that.
I did. I'm a lawyer.
Okay, I respect that, both sides. All right, so at this point, why don't we, I said that I was going to step off for the gathering of the evidence. Let me not do that. I'd like the council to just make sure that all the evidence, the exhibits are in order. You'll note your contentment on both sides. If you folks can take a look at the verdict form as well, I don't know if you already have. It's not complicated, but do you want, Mr. Braille, have you seen the verdict form?
No.
All right, so why don't you, officer, do you mind? Officer?
Commonwealth is content with that.
Same,
All right. All right, content with the verdict form, but we're still working on the exhibits,
Yeah,
right?
we'll take a few minutes.
Yeah, that's fine. I just was checking with our court officers about the availability of this courtroom this afternoon, so that we're checking on that.
ADA Gubitosi on behalf of the Commonwealth, is the Commonwealth content with the exhibits?
Yes.
Attorney Bradel on behalf of the defendant, is the defendant content with the exhibits?
Yes.
And that would be for both of you exhibits number 1 through 98. Correct?
Plus the chalk, Mr. Clerk.
Yes, and the jury instruction.
Thank you.
Yes.
Okay, 98, I thought we had, weren't there 100 exhibits?
No, 98.
Okay, all right. I'm sorry, okay. All right, so, and Mr. Wayne, I think it makes sense, as in a jury trial, for you to swear our court officers in.
Could you all raise your right hands? Do you solemnly swear that you will keep the court in some convenient place until he has agreed that you will not suffer any person to speak to him, nor speak to him yourselves, unless by order of the court, or to ask him if he has agreed? And when he has agreed, you will return him into court unless the court shall otherwise order, so help you God.
I do.
All right, we will stand in recess for my deliberation.
All rise, please.
bottom dead repair.
I want to talk just quickly about some of the things Ms. Bennett said. She told you that Suzanne went into self-preservation mode after the shot through the door. Did you hear it? She went into self-preservation mode. By sprinting down the stairs to grab a hammer, bash through a door, injure herself right here, trying to get through it to get to him. Self-preservation mode. And she picks up his gun, and she told you what she did with it. Twice. And we told you she was going to tell you that. Self-preservation mode. They say she put Mr. Barron's hand on the gun to fire the shot. Really? His left hand? He's a right-hander. She put his left hand on the gun? This is her genius plan? Okay. Does that make any sense? She staged the crime scene, they say. The world's greatest performance. Let me talk to you about the self-defense charge that you're going to get, okay? A defendant is justified in using force that's intended or likely to cause death or serious bodily injury. Justified in using force that's likely to cause death or great bodily injury when they reasonably believe that the use of such force is necessary to prevent death or serious bodily injury to herself or the commission of a forcible felony. What's a forcible felony? Aggravated assault by strangulation, which he'd already done downstairs. Aggravated sodomy, which he'd already done downstairs.
I muted it. Didn't even know it. Oh my
Malice murder. Sorry.
Oh my God.
Malice murder, which he told her he was going to do. Don't close your eyes tonight. I'll shove this gun
Like
down your
boo-boo the fool
effing
right
throat.
now.
The point is that Suzanne doesn't have to intend to kill or shoot James David Barron for self-defense to apply. The force is the shot.
What?
She doesn't have to intend to kill him in order to have self-defense apply. She only has to reasonably believe that the force is necessary to prevent death or serious bodily injury to herself or the commission of a forcible felony.
I feel like that door, bro.
Forcible
You shoot
felony,
somebody through a door,
strangle.
That's like,
Don't close your eyes tonight,
I don't know. It just don't sound right. You know what I'm saying?
or aggravated sodomy,
Shoot through a
which
door?
is the forcible performance of a oral sex act. That's it. She doesn't have to intend to kill him. She just has to be concerned about these things. To boil it
I
down
don't know
even
about
further,
self-defense, man.
self-defense
That door-
means Suzanne's allowed to use deadly force if she reasonably believes it's necessary to prevent death, serious injury, or forcible felony, even if the shot that killed Mr. Barron was not the outcome that she intended. She doesn't have to intend to be killing Mr. Barron to claim self-defense. And the state has the
So
burden
say
of
use the force,
proving to
use the
you
force.
beyond a reasonable doubt
Boys that verdict in
that
2
her
hours.
action, that shot, that one shot, was not justified. The judge is going to tell you this as well. He's going to tell you the defendant's use of deadly force may be justified even when there's not even been physical contact between anyone. There's no prerequisite for actual physical contact. We have loads of physical contact in this case, but you don't even need it. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's life is in imminent danger, the defendant is in imminent danger of serious bodily injury, or a forcible felony is about to be committed, the defendant's use of deadly force may be justified. And the state has to disprove that to you beyond a reasonable doubt. You can think of it like this. At the top would be, let's say, we've proven to you beyond a reason, we, the defense, which we don't have a burden at all, but let's say we had proven to you self-defense beyond a reasonable doubt. Verdict would be not guilty. Even if you think it's probably self-defense, not guilty. Perhaps self-defense, not guilty. May not be self-defense, not guilty. Unlikely self-defense, not guilty. Probably not self-defense.
My boy said, I've never
guilty.
heard people cough so much as I've heard.
Highly unlikely self-defense. The
That's
verdict
funny 'cause they
still,
just coughing.
under the law, is not guilty. The only way you get to the guilty box is if the state's proven it beyond a reasonable doubt that it was not. That's the law.
Law.
Remember, the state has the burden of proving to you two things. One, that it wasn't self-defense. We just talked about that. And if they get past that, if somehow they got past that, we go into here, each of the elements of the charge, offense, and the indictment. So let's talk about what those are. Malice murder. Here's the indictment. Unlawfully, with malice aforethought, causing the death of James Barron by shooting him. It's a malice murder charge. What does that boil down to? With malice aforethought, causing the death of James Barron by shooting him. Malice aforethought's the intent to kill without justification. In other words, without self-defense. Intent to kill. Deliberate intention to unlawfully take the life of another person. Deliberate intention. Abandon and malignant heart. That's the malice murder count. That's what it boils down to. That shot through a closed door, that shot through a closed door where she can't see a single thing on the other side of that
I
door.
don't know about this motherfucking. I don't know about this defense, bro.
And the only thing she's got to know where he is hearing. And I guess, under the state's theory, once you take 3 or 4 classes at a gun range, you've become James Bond or Jason Bourne. I know where he is, and a kill shot through a closed door. It's insane. She tells him 1,000,000 times, I'm trying to shoot the lock, I'm trying to shoot the lock, I'm trying to shoot the lock off, I'm trying to shoot the lock off. No, government says, ignore that. Ignore that. She's intending to kill him.
Why are
through a
you trying
closed
to
door,
shoot the lock off?
and she can't even hear where he is. The only time she hears where he is, he's in the bed. Remember? He's on the bed. By the way, how would she cite this in? from this height. When you're really trying to, right? She's 5'5". You guys are going to have this door back there. Play around with that. You're going to see
There's a lot of
this
caution
shot did
there.
not go down like
There you
that.
throw it, my boy.
It was like this. Intent to kill. Insane. Insane.
Was she locked in a closet or some shit?
Aggravated assault. We've only got 2 more, okay? Aggravated assault. This one's a little bit trickier, okay? And I'm going to go through it with you so you don't, I want you to make sure that you know it. Assault James David Barron by firing said weapon through a door in the direction of James David Barron. Assault is firing the weapon through a door. That's the act. The act is the firing of the weapon. Assault by firing said weapon through a door. You're going to have this in your charges, so I think it's on page 11 that the court will send back. An assault means either she intended to cause the injury by shooting him, meaning the same thing before. We got Jason Bourne over here shooting through a closed door. She'd have to be proven beyond a reasonable doubt to have intended to hit him with that shot. Ignore all her statements, you know, that she's trying to shoot the lock. She's not really trying to shoot the lock. She's trying to kill him through a closed door. She wants to hit him through a closed door. Of course, she waits till he's behind a closed door. He's down in the living room asleep. She really wants him dead. She waits till he's behind a closed door. Okay. Intended to kill him, actually intended to injure him, or the one that's in bold. The one that's in bold. Commits an act which places another in reasonable apprehension of immediately receiving a violent injury. Commits an act that places another in reasonable apprehension of immediately receiving a violent injury. What's the act? Remember, the act is by firing a weapon, right? So, commits an act by firing a weapon through a door which places another in reasonable apprehension of immediately receiving a violent injury. What does that mean? It means the government has to prove beyond a reasonable doubt that he saw or heard or perceived the shot after she shot it, but before it hit him. After the shot, but before it hit him beyond a reasonable doubt. That's literally what they have to prove. Yeah. It's insane. It's insane. And you remember this? Do you remember when the medical examiner testified? And I said, Dr. Zhang, would you expect that a human being would be able to perceive a shot after it's fired, but before it strikes them?
These closes is crazy.
And she said, she waited a long time. She goes, I don't know. That's what she said. And I said, wait a second now. Wait a second. Dr. Zhang, we talked a couple weeks ago on the phone, and I asked you this very same question. I said, do you think they'd be able to see it, perceive it, hear it before it hits them? And you told me you didn't think so. And she said, okay, but I don't know today. There is zero evidence of that. Zero. Not, forget proof beyond a reasonable doubt. Nothing. Nothing, and that's the law.
Zilch.
This is very important. It is not enough to show that he's in a defensive position, which he's apparently selected, which is apparently the worst place, clearly the worst place in the world to pick when somebody's telling you they're going to shoot a lock off a door. but apparently he selected that in a defensive position. Doesn't matter. It doesn't matter that he's in a defensive position. Her saying, I'm going to shoot the lock off, I'm going to shoot the lock off. That is not what she's charged with. That's not it.
He said blame the nigga that died.
He's got to perceive the shot after the shot, but before it hits him. No way. Last one. Last one. Damage to property. This is a property crime charge. Damage to property. They charge her with a felony of damaging property. Okay, what do they have to prove? They have to prove knowingly and without authority she interfered with a door. Knowingly and without authority interfered with a door. Also on page 11 of your charges, you'll see this. Without authority means without legal right or privilege. Without legal right or privilege over what? The door. That door. That door that she owns, the government has to prove that she was without legal right or authority over a door that she owns beyond a reasonable doubt. And that she knew she didn't have legal right or authority over her own door beyond a reasonable doubt. It's insane. It's insane. But that's how they want to get you to a felony murder conviction on a property crime for a door she owns and that she would have absolutely no idea to know she has no authority over. Bottom line, folks, malice murder, they have to prove beyond a reasonable doubt she intended to kill him. Behind a closed door, through the use of her fantastic hearing and her expert marksmanship. Aggravated assault, they have to prove that Mr. Barron saw, heard, perceived the shot after it was shot, but before it struck him, based on zero evidence to that fact. And in fact, evidence from the medical examiner that she previously told me that she didn't think so. And with the damage to property, that she knew she was without authority, that she was without authority over the door, and that she knew it beyond a reasonable doubt. That's what they have to show. Now, the tampering charge, we don't have anything to say about that. Hang it up. If after giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, unsatisfied, then that is a doubt of the law, and you should find the defendant not guilty. That's what the judge can tell you.
No, my dog.
If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty. It would be your duty to acquit the defendant. If you're going to find her guilty, it's easy, guys. It's easy. Evidence has to be so overwhelming, you don't have a choice. So overwhelming, you don't even have a choice. Is that what you got? facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Remember, they had two jobs. Prove to you beyond a reasonable doubt that she was not justified. No way was she justified. In no way, not even close. And if they do that, then you move on to the elements. And we went through those. I'm going to tell you a little bit more about some of the self-defense charges you're going to get, okay, from the judge. Evidence of prior difficulties or lack thereof between the defendant and the alleged victim has been admitted for the sole purpose of illustrating, if it does, the state of the feeling between the defendant and the alleged victim, or the reasonableness of alleged fears by the defendant. Right? The prior violence by Mr. Barron has been admitted so that you can know what she could expect to determine her reasonableness in her behavior. You may consider relevant evidence the defendant's been subjected to acts of family violence or dating violence in order to establish the defendant's reasonable belief that deadly force was immediately necessary. Immediately necessary. If she can reasonably know that he's coming out of that door whenever he's good and ready, that's how you can know how necessary it was for her to try to get her phone and get out of there. The defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing action of the alleged victim is sufficient to create a reasonable belief the defendant's life is in imminent danger, the defendant is in imminent danger of serious bodily injury or a forcible felony is about to be committed, then the defendant's use of deadly force may be justified. He doesn't even have to have contacted her or touched her before. Of course he did. Her body's proof of that. Self-defense means she's allowed to use deadly force if she reasonably believes it's necessary to prevent death, serious injury, or a forcible felony, even if the shot that killed Mr. Barron was not the outcome she intended. Here's one. We haven't talked about this one yet. Judge is going to tell you that she is under no duty to retreat. A person who's not the aggressor is not required to retreat before being justified in using force that she reasonably believes is necessary. You heard a lot of evidence about whether or not she could leave that night, how she could leave, what method she could use. She could take that nice path down the road that you saw the video of, walking out the front door. She could go to a neighbor she doesn't know, except they gave her a basket once, so then obviously you can show up at their house at 1 a.m. and expect he's not going to be right on your heels. You can find a spare set of keys that apparently he doesn't even know where they exist on 12/28/24, even though he's got the only keys to the functional car right there in his pocket. And when we show the video of that little side room, you see any keys on the table? No. He took her phone just so she couldn't leave. That's why he had it. That's what it was for. But she doesn't even have to leave. She's under no duty to leave a home that she co-owns, and frankly, that she paid more for than he did. No duty to leave under the law. We showed you she couldn't, but she doesn't have to. Couple more things. and y'all probably won't get here, okay? But just so you know, felony murder is murder. Malice murder is one of the murders, felony murder is another murder. They're all murder. Don't be thinking, it's something other than a murder. Felony murder is a murder. Last thing. And I shouldn't have put it up there because you guys are already reading it. But if somehow you get through all of the self-defense stuff and you guys feel like the government has just squashed that somehow beyond a reasonable doubt, there's no way, there's absolutely no way she could have been thinking she needed to be free and safe and afraid. If you got past that, then you got through all the elements, right? You'd have this additional option, okay? The court's giving you an option of an involuntary manslaughter as a lesser offense. And I'm not telling you to do this, I'm just telling you this is one of the options after you've already gone through all the other stuff. Involuntary manslaughter, the defendant may not be guilty of malice murder in count 1 or felony murder in counts 2 or 3, but still be guilty of involuntary. For involuntary, the evidence must prove the defendant caused the death of another person without intending to by committing the offense of reckless conduct. What's reckless conduct? Causing bodily harm by consciously disregarding a substantial and unjustifiable risk that their act would cause harm to someone else. It's an unintentional killing through reckless behavior. It's another option for you. It's not what I'm asking you to do. It's not what I'm asking you to do. I told you at the beginning you weren't going to meet her. Remember? I told you. And you didn't. You didn't. And you won't. You still won't. This woman is gone. Almost as much as James Barron. It's gone. And our position is, he did it to her. She was in fear for her life when she pulled that trigger, guys.
Trying to do.
And there's only 12 people in the world that have the power to give it back to her. They're all in this box. I have to guess what Miss Bennett's going to talk about when I sit down. I'm about to sit down. And then she gets to go again. One of the reasons that the government gets to go twice is because of the burden of proof. The burden of proof is so high for them. It's so high they get to go twice. So I got to guess what she's going to say, okay? And I don't know, but I'm going to just guess. It's going to be a lot of stuff about what happened after she fired the shot. A whole lot of stuff about what happened after. Probably all about what happened after. What happened after the self-defense doesn't change the fact that it was self-defense. It can't. You don't show malice by flushing shells down the toilet after a suicide attempt, or having a towel in the room, or making up a story to cover the fact that you had to flush them down the shelves. I mean, that you did flush them down the toilet. You don't.
I don't like
There's going to be some stuff I forgot, and I'm not going to be able to get back up. Like I said, I can't get back up and respond to the things they're going to do. No, it's not because I don't want to. Return verdicts and not guilty on all counts except for the tampering, please. Thank you.
Goddamn.
Judge, would it be possible to get the jury just a brief 5-minute comfort break? 4:10.
Folks, what we're going to do, and I have no idea how long this will continue. I'm guessing roughly an hour and a half. So let's go ahead and take a break now, and we'll come back at 11:15. We'll have, assumedly, Ms. Bennett for the final conclusion remarks of her closing statements, and then I will give you the law, which will take about 20 minutes or so. With that, 15-minute break. Thank you.
I'm never going to remember.
Hearing?
No, the standard.
Oh, I don't know. I appreciate everyone's professionalism. We're getting at about capacity, not quite there yet. I will say that if you are, if you work in the courthouse, court personnel, local lawyer, local paralegal, those types, if you are not sitting in the first 2 rows, I'm not requiring that you do that, but I ask that you do that. And I understand that you may not want to sit certain places. I'm not getting any of that. But if you happen to be in the back row and you happen to be court personnel or someone along those lines, you would be authorized to sit in the front row, and I think it would help the Sheriff's Department. Again, I'm not kicking anybody out at this point, so just want to be clear on that small request. With that, we'll be in recess until 11:15.
Okie dokie. It's just fully charged. Weird.
redefined.
Sent the enemies packing. Reload, reload! Dying!
The safe zone is shifting. Loadout airdrop incoming.
Is this a raid? How rude. Oh, what a loser.
Double kill. Triple kill.
Using bandage.
The safe zone has been redefined.
How rude.
Oh, he had that shell. swap the motherfucking gun. Should've just swapped to another gun. Oh shit.
The enemy is here! This isn't fun! Reload! Reload!
Damn. This nigga jumped right in front of my bullets, bro. Took him for his twin. You heard me? Took them shells for his twin, though. For his twin, though? For his twin, though? Show me. Show me. Not for the twin, though. Not for the twin.
redefined.
I wanna go where it's smoking at. I don't see niggas want to pass the Dutch round. What's up?
This isn't fun! Reload! Reload!
I think so. I hope so.
Loadout airdrop
Yeah, I'll
incoming.
get back to you. Before the jury comes back, I just have to make sure my PowerPoint's up. Thank you. Nope. Here we go. Thank you, Judge.
You want it still up?
Yes, is that okay to just leave it like that?
I see your problem with it.
Thank you.
I appreciate court personnel moving to the front 2 rows. I did notice that. Thank you. Jury's not quite ready to come back. They'll be back in a couple moments. Again, I have 45 minutes to an hour roughly.
Yeah.
So at 45 minutes to an hour roughly, I will begin jury instructions. Many times court personnel decide to leave, which is fine. I will give you about a minute to get up and leave if you want to do that. Absent that, please don't leave during the middle of jury instruction. So again, after conclusion from the state, I will pause a beat, and if you want to leave, that's perfectly fine, and then I will begin jury instructions. Thank you. Let's bring them back. All right, welcome back. Thank you so much. Please be seated. Folks, as I discussed, we'll now begin final closing argument by the state.
Thank you, Your Honor. I wanted to, before I got going, really, I wanted to briefly respond to just a few things about the charges in the indictment and the elements that need to be proven beyond a reasonable doubt. Where'd the microphone go?
To your left.
Sorry, I realized it wasn't over here. I want to talk to you about the elements of aggravated assault. So, Mr. Willis is absolutely right as far as with aggravated assault, basically you either have to prove an intent to injure or that someone was in reasonable apprehension of receiving injury. You can do either or. You can think that one happened, you can think that both happened. Either that there was an intent to injure or that someone was in reasonable apprehension of receiving injury. In this case, there's both, and I want to explain why. We already really talked about the intent to kill with the malice, right? So the intent to injure in this case was the fact that she walked up to the door, put the gun right up to the door, fired in the direction of Mr. Barron. The difference between the intent with the aggravated assault and the malice murder is that with aggravated assault, you don't have to prove when she did that she intended to kill, just that she intended basically to strike her target. Whether or not she actually did isn't the question, it's just whether there was the intent there. When she walked up to the door with her gun, placed it 6 inches from the door in the direction of where Mr. Barron's standing and fired, if when she did that she had the intent to injure. That's one way you can find the aggravated assault. And or, meaning you can find that and the other way, or just reasonable apprehension, you can find that Mr. Barron, what she did when she walked up to the door, held it up to the door, and started yelling, "I'm gonna shoot the door, I'm gonna shoot you, I'm gonna shoot you." And the thing with that is, Mr. Willis is assuming what she said was, "I'm gonna shoot the lock off, I'm gonna shoot the lock off," because that's what she says that she said, right? Like, we're just assuming she was saying, "I'm gonna shoot the lock off David, I'm gonna shoot the lock off David," because she says that's what she was saying. What we know is she's yelling something that has Mr. Barron scared enough to be hiding behind the wall. What I think that the evidence shows is she's yelling, "I'm gonna shoot you. I'm gonna shoot you, I'm gonna shoot you, I have a gun, I'm gonna shoot you." Maybe she's yelling, "I'm gonna kill you." She's yelling all of these things that has caused Mr. Barron to literally hide like this behind the wall. That's reasonable apprehension of receiving injury. He's terrified. Ladies and gentlemen.
Judge, I have to object to she didn't tie it to the shot, which is the allegata, so I object to her explanation.
Without commenting on the evidence, the court is not commenting on the evidence. The lawyers have a certain amount of discretion as it relates to their argument, and I will authorize said argument.
That's reasonable apprehension of receiving injury, ladies and gentlemen. Is David hiding behind the wall while she's yelling, "I'm gonna shoot"? Why else would he be hiding behind the wall if not because she's yelling that she's gonna shoot him? That's reasonable apprehension of receiving injury. The judge is not gonna tell you whatever Mr. Willis said about the time between the bullet leaving the gun and hitting Mr. Barron. That's not what the judge is gonna read you. You will not hear the judge say that to you. That's what Mr. Willis wants you to believe. That's his argument. He has every right to argue that to you. You're not gonna hear that from the judge. And I wanna make that very clear. What the law requires is that Mr. Barron be in reasonable apprehension of receiving injury from the defendant's actions.
Judge, I re-object to counsel's explanation of the law being factually inaccurate.
Objection is noted. Continue.
So I wanted to make that very clear to everybody. As far as the criminal damage to property in the first degree, it's a property crime that places someone's life in danger. That's what makes it criminal damage to property in the first degree. There's something called criminal damage to property in the second degree that's just damaging property. If I took Ms. Bagwell's phone and smashed it on the ground, that's what that is. What criminal damage to property in the first degree, and the reason why this statute exists, is for situations just like this one. Drive-by shootings, when someone shoots into a car while someone's occupying that car. That is criminal damage to property in the first degree, because you've damaged property that endangers somebody's life. A drive-by shooting of a home, someone shooting into an apartment door, someone shooting into any wall that someone's on the other side of. That's what this charge is for, ladies and gentlemen. This isn't just some property crime that the state has decided to just kind of shove into a felony murder statute and give it to you because we're just petty and angry. Criminal damage to property in the first degree is created for situations like this one, when you have someone hiding behind a locked door and someone chooses to get a gun, shoot through the door, and endanger that person's life. What makes it a felony murder is if that person dies. Same thing with a drive-by shooting. If you shoot into a car that someone's occupying and the person doesn't even get hit, that's criminal damage to property in the first degree. If that person were to die, it becomes felony murder. That is what criminal damage to property in the first degree is created for. As to the without authority, they are trying to basically get you to find the defendant not guilty of criminal damage to property in the first degree because of the without authority. Because for some reason, Mr. Barron should have known to yell out, "Before you shoot through the door, I do not give you authority to do this. I do not give you authority to damage this door," for her to know not to do it. This is joint property. Ladies and gentlemen, if they wanted to sell the home, she has to get Mr. Barron's permission. If she wants to do anything with the home, he owns it. Their names are both on the deed. It might sound ridiculous, you might not agree with it, you might think it sounds weird, but that's the law. And so, When you took your oath as a juror to follow the law, this is what we are asking you to do, is follow the law. It might sound funky that the without authority means she had to, it doesn't mean she has to ask permission to damage her own door. That's not what that means, ladies and gentlemen. What it means is you can't just go damaging property without authority. They had joint property. The law tells you that you can't do this. That's why she was charged with it. If she was allowed to damage her own door, she wouldn't have been charged with it. I want to talk about the self-defense, and I put a question mark behind it for a reason. And that's because at no point throughout this entire case did this defendant say that she shot Mr. Barron in self-defense.
Crazy.
Not once.
Right back.
Not a single time. What she said was, I wanted to get my phone, so I was trying to shoot the lock off the door, and it must have accidentally killed him. That is called accident. That is not called self-defense. And I gave her many opportunities. When you got that gun and brought it upstairs, were you going to use it to defend yourself? Or were you going to use it to try and shoot the lock off? I was trying to shoot the lock off the door. No point does she ever say that what she did, that her actions were to defend herself. She wanted to get her phone. That's what she told you. Again, I don't believe the evidence shows that Mr. Barron even ever had her phone, but if you believe that he did, it's still not self-defense, regardless of if he had the phone or not. That's not the point. The point is, shooting the lock off a door to get your phone is not self-defense. That is an accident. She is saying she accidentally killed him because she doesn't want to have to admit that she intentionally shot and killed Mr. Barron. I want to talk to you about why this isn't self-defense, and I want to go back for a minute, because y'all read a million text messages. I know you're probably sick of them. I know you've seen a lot of them. But Mr. Willis was incorrect when I said that I was going to get up and talk about everything that happened after the shot was fired, because what I want to talk to you about is everything that happened before it, right? Because for her to be in fear for her life, you have to believe that what she was saying about Mr. Barron is true. Mr. Willis was just having you assume that all that was true. But we know that this defendant doesn't know how to do anything but lie. And Mr. Willis conveniently didn't talk about a single one of her statements in Investigator Mefford's interview or on body cam, and there's a reason for that, because they're all lies, and he wants you to just gloss over that. He wants you to just forget about the times that she lied over and over and over to Investigator Mefford, to the deputies, to you, on the stand. He wants you to forget about that, so he didn't even mention it. So I want to talk to you about why we know that everything she said about Mr. Barron is a lie. And this is the crazy thing about murder cases, ladies and gentlemen, is that defendant gets to get up on that witness stand and she gets to say whatever she wants about Mr. Barron. She can tell you these horror stories about him. And guess who's not here to defend himself? He doesn't get to say a single word to rebut a single lie that she got up there and told you. And so in order to figure out if you think she was telling the truth or not, we need to look at the behavior of Mr. Barron and this defendant before that night. Because that will tell you everything that you need to know about what kind of person she is versus what kind of person Mr. Barron was, because he doesn't have the opportunity to get up and tell you himself. So let's look at this text from October 12, 2024. She says, "I'm so wet thinking about sucking your cock." Hello, hello. He says, "I would love that." That was 2 hours ago. Offer is gone. He says, "I was charging my phone." How about October 28th with Meg? The hair incident, ladies and gentlemen. We cannot forget about the twins' birthday party in September when Mr. Barron told his son's wife's daughter, sister-in-law, that she had pretty hair. Enter 2-month argument about that. "I'm worried about you going trick-or-treating with Meg being there. I don't trust her. I hate that I even have to think about this. It is obvious you are attracted to her. Please let me know if you prefer her. I have been through this. It has made me sick all day thinking about it. Men are visual. You are apparently attracted to her. If you want her, go after her. I do not have hair like that. I am older." What is this horribly verbally abusive, controlling man say back, "Baby, please don't worry, I will not go if you wish. There is no attraction on my end." Talk about isolation. David Barron missed the last opportunity he ever would have had to trick or treat with his grandkids because this defendant didn't want him to go because Meg would be there with the pretty hair. Talk about manipulative. Talk about controlling. Talk about isolation. Fast forward a month later, we are still on the Meg situation. He's not in the mood to sext. So he says, leave pussy alone for now, but she, that sets her off, once again, we should have phone sex. Pussy needs lots of attention. He says, I know, but I'm zeroed in on TV. He just wants to watch TV. Never mind, she says. After this weekend, I do not think I excite you. Maybe if I have pretty hair. He says, I am so in love with you. That horribly, verbally, and physically abusive man, that's his response to this out of nowhere argument. I am so in love with you. She says, I wonder, I do not have pretty hair. I am not young. He says, you have beautiful hair and are beautiful. I want you to desire me. You act like we are married and we are not. I have no ring on my finger. What a horribly abusive man he is. So isolating and controlling and manipulative. Keeps going. I do desire you, babe. She says, I am not sure. We never text sexually like we used to. We are not married. I think you need some young pussy with pretty hair. Not interested in mine anymore. Barely wanted it this past weekend after not having for 10 days. His response, I only need you. I'm gonna hug you now to stop this. Wow. He is just a horrible, horrible person. How about December 5th? When are you going to ask me to marry you? When are you going to ask me to marry you? She sends that text twice, 8 minutes apart, because he didn't respond in 8 minutes. He says, certainly soon. She says, why a secret? I'm not 20. Never mind, I don't want to marry. I can survive alone. His response, what? I mean, half of the time that this happens, these fights come out of nowhere, and he has no idea what's going on. It goes from I love you to you hate me and you don't want to marry me. She's begging him over and over and over again to marry her. But she wants you to believe that while this is going on, remember it's December, the violence is escalating. It's escalating, ladies and gentlemen. She's already been sodomized, raped, beaten, begging him to marry her. Long text, still on December 5th. I don't want to get married. I will take care of myself. I don't care about what anyone thinks, but I do think about you way too much. You do not think of me in the same way. I cannot make another mistake. I'm really good. I will be fine. I always survive. I don't need anyone to take care of me. I need alone time to think this through. You did tell me 2 weeks ago this moved way too ... You said you didn't have time to think about me or getting a ring because we got a house too fast. I'm beginning to agree with you. I'm not the woman for you. You need somebody more dependent on you. You're a good person. He says, I certainly want to marry you, and I have the same feelings for you. She says, no, you don't. I'm going to have this discussion again. If you wanted me, I would have known by now. Go find what you want. Well, I thought that he was so controlling of her. I thought that he was isolating her from her family, not letting her see her family. I thought that he was raping her. But she's telling him that she's angry because he doesn't even want to have sex with her because he's not interested. But I thought that she was off hiding in bedrooms during family events because he basically won't let her talk to anyone. December 15th, I know it's really small, but you'll remember this one. I'm not going to read it all for the sake of not needing to, where she says she gets angry because he doesn't respond to her text in 20 minutes. He says, I'm very interested. I thought you were going to sleep. And then he's talking about wrapping her daughter's Christmas present. He says, I was wrapping your daughter's Christmas present. Enter pages and pages of unresponded to text messages from Suzanne because he didn't respond to her in 20 minutes when she said that she wanted to be writing his whole hard cock squirting all over him. Enter pages and pages of yelling by Suzanne to him because he didn't respond to her for 20 minutes to that text. But I thought he was so controlling and manipulative and abusive. January 13th, at this point, he's already, we know, pointed the gun at her, according to her, raped her, beat, strangled, all the things. I do love you, I'm struggling with this, trying to understand what happened and why. I feel like perhaps I'm not all you need. You were the one thing that was solid in my life. I want to believe so hard that Lilia or Laura mean nothing to you. Let's be patient with each other, and I know we can get through this. And he says, yes, we can. She doesn't say, you meant everything to me until you beat me, raped me, strangled me, and pointed a gun to my head. I understand those were the two rules, right? Apparently, she's allowed to yell at him for literally everything else he does, but she's not allowed to mention the physical abuse, so she just, leaves those out of the continuous rage texts to him. This continues. I need someone that fits me, that lifts me up, I feel inadequate with you. I am not enough. I feel unwanted. I feel like if I let this go, that you're texting them every day and talking to them on your ride home and enjoying their company. I'm never enough. Please do what you need to do. And what's David's response? Because don't forget, if she tries to leave him, he's going to kill her, right? That's what she wants you to believe. If you leave me, I am going to kill you. What's his response? Okay, let's end this. You will never trust me no matter what I do or say. There's nothing that I can do to satisfy you. Yikes. He's super abusive and manipulative and angry and controlling and threatening. Then all of a sudden she starts to dial it back because she doesn't want to leave him, right? Because she's so desperate and obsessed for love. So the second he mentions breaking up, now her tune starts to switch. I feel all alone. I know you never understand. I thought you loved me. All those things. He says, I don't care for anyone but you can't understand. I won't come this weekend and we'll hire an attorney on the house situation. He's just done with it. He's tired of the same argument over and over. What he did wasn't right, but either break up with him or try and move past it. But to do what she's doing, he can't take it anymore. Please call me. Don't hire an attorney. Please call me. But he's so manipulative and controlling and obsessive and abusive. She's the one who won't let him go. She's the one begging him not to leave her. January 21st, all these texts, I'm not going to read them all. It's just a ginormous pages and pages rant without any response from David about how heartbroken she is about Lilia, how alone she is. Who's Lilia? I deserve an answer. Who's Lilia? I fell in love with you. I've been hurt. Why couldn't you just love me for me? Over and over and over, and he doesn't respond. But according to Dr. Elkon, him ignoring her is also abusive, right? And manipulative, because he can't do anything right. If he responds, that was probably abusive. If he doesn't respond, that's also abusive, according to her. When all he's trying to do is just not engage in this crazy, repetitive behavior. February 24th, and again, talking about Lilia, I deserve more to fight over a woman like that. Over and over, she's fighting about Lilia. He says no feelings towards her. Why do you care for her? I mean, rant after rant. Then let's talk about this text. This is to Dana. This is a text from the defendant to Dana. I'm not going to contact him. I'm tired of chasing. If he wants to come, he can find me. I found out on my own. He was honest. She's talking about that. Then she says, I told him I don't mind him texting other women as long as they're friends. I have guy friends. That's not true. He can't even say a woman's hair is pretty without it turning into a 2-month argument. She told her on January 20th she's not going to contact him. Here's January 21st. Text after text after text after text. How about how much he made her feel safe? There's plenty more than this. I only put in 3. The one I want to bring your attention to most is February 17th, the day after he attempted to anally sodomize her to the point where she had to flee her home in nothing but a t-shirt and was arrested for DUI. Thank you for keeping me calm and wanting to help me. I feel so safe and loved by you. Ladies and gentlemen, I asked Dr. Elcon, you read all 4,000 pages of those text messages, right? Yes. Did you see a single text message, one single text message, where David called her a name? No. Did you see one single text message where David says something verbally abusive to her? No. Threaten her? No. Not one. How many text messages did we see? She's calling him a piece of shit, cursing at him, calling him names, said something about he's a pile of doo-doo, over and over. The only abuser, the only evidence of any abuse is by her to him. That is the only evidence that you have seen of domestic abuse is from this defendant to Mr. Barron. That is it. And I want to talk about the bruises. This was taken by Investigator Mefford. This was taken by somebody who works for the defendant on an unknown date. Look at the difference in those bruises. That's why Investigator Mefford corrected himself and said, once I had a chance to actually compare them, I realized that they don't look the same. They look completely different. It's way darker. How about the tops of her arms? You see that big bruise on the top of her arm? Where is it? I don't see anything. How about the redness down here? Do you see anything on her arm? I don't. Where did those bruises come from? I have no idea. What I do know is they didn't come from Mr. Barron, because everything she says is a lie. What I do know is that she continued to reach in both of these holes to try and unlock the door. Could have caused a bruise. What I do know is that the paramedic came in and said that bruises will show between 20 minutes and 2 hours. This is taken at 6:30 on the left. It's taken at 6:30 the following morning. That's about almost 6 hours since Mr. Barron has been dead. Where's that bruise? It's nowhere. You know what else I know? Is that this defendant spent 3 hours flopping around on the ground on the crime scene. She's leaning up against the corner of the house with her forearms. If you want to watch the body cam again, just to look at her behavior, watch how many times she bangs her arms up against the wall or the corner of that house. Watch how many times she falls to the ground, rolling around. Watch the interview. Watch how many times she's banging up against the wall. She falls onto the chair. She's rolling around on the ground. I have no idea. A million different things she did could have caused some of those bruises, but what I do know is that they look completely different. And I have no idea when the one on the right was taken, or by who. Mr. Willis told you this. This is the law the judge is going to read. But what he didn't explain well was that self-defense, someone is justified in committing murder only when it's necessary to prevent death or great bodily injury. So I want to talk to you about that, because let's say, for argument's sake, you believe everything that she said about what happened the night of March 7th, right? Let's say that you believe that he did force her to commit aggravated sodomy on him. Let's say you do believe he put that gun to her mouth. Let's say you believe all of that. You also have to believe that that was the only reasonable way and that it was necessary to shoot that door to prevent death or a forcible felony against herself. And he's right, there's no duty to retreat. There's no duty to retreat, but the reason that retreating comes into play is because, is it reasonable and necessary? What does reasonable mean? It's not reasonable to her. It's not reasonable to the defendant. It's reasonable. The belief must be reasonable. That is, a reasonable person would believe that that use of force was necessary. What that means is this objective, reasonable person. You take an objective, reasonable person. Would an objective, reasonable person believe that after being beaten, threatened with death, forced to commit oral sex, a gun pointed to your mouth, Would a reasonable person think the best way to protect yourself is to take a gun, walk up to the door where the person who is armed with a weapon that's just been pointed at you in your mouth, that the reasonable way to defend yourself is to shoot through that door? In what world, ladies and gentlemen, would someone who is in fear for their life by a person who is armed on the other side of that door not think that if I shoot at this door, he's going to shoot back at me? In what world? She is so in fear for her life that she thinks that's the only way to protect herself, but she doesn't even think about the fact that if she shoots through this door, he's going to shoot back at her? What if she had missed and he was still alive, armed with a gun? And she doesn't for once take a second to think that he might shoot back at her? What if she was trying to aim at the lock, shoots the lock off, gets in the door? What was her game plan? He has just beaten her, according to her, forced her to commit oral sex, according to her, put a gun to her mouth, according to her, and she thinks she's going to shoot the lock off, walk in and go, can you please give me my phone? I really want to call an Uber so I can leave. And then he's just going to hand the phone over, she's going to walk downstairs, stand outside of the porch with all the wild dogs, and call an Uber. And he's just going to hang out upstairs and let her rideshare come along and take her away. That is the most unreasonable thing I've ever heard. If you are in fear for your life by a person who is armed with a gun, the last thing you're going to do is follow him up to the locked door and shoot at him. You're going to get out. She's friends with one of the neighbors that gave her a gift basket on Christmas with a handwritten note. But she wants you to believe that it was more reasonable for her to shoot into a room with an armed person than to go knock on the neighbor's door at 1 a.m. She wants you to believe that these wild dogs are the reason that she didn't want to walk out of the house. I'm not making that up. She said it. I'm not even trying to make fun of her for it. That's what she said, so we have to address that, ladies and gentlemen. She wants you to believe that this was reasonable to a reasonable person. That's why I know that David Barron never had his gun. Because if he had his gun, there is not a single chance she would have ever shot into that door. There is no chance that if he had that gun and he had just threatened her with it, that she would have gone up there and she would have shot into that door. Because what if she had missed? You're also going to hear about excessive force. Again, for argument's sake, let's say you believe everything she said about March 7th. You're also going to hear the judge tell you that you're not justified in using excessive force while you're defending yourself. For example, using excessive force would be trying to shoot the lock off the door to get a phone. That's excessive. That is so excessive. To use reasonable force is what you have to find in order to find her not guilty. Shooting a lock off of a door to get a phone is excessive. And you're also going to hear about revenge because you're also not justified in using force basically just to get back at someone. So again, let's say you believe everything she said is the truth. That he made her do all those things, he points a gun at her, you heard what she said. I have a gun too, David. That's what you heard her say. So let's say you believe all those things are true. Now she's angry because he has just forced her to commit oral sex on him. He's just pointed a gun at her. She's mad. I'm going to show you I have a gun too. Walks up the stairs and shoots. That is not self-defense. That is revenge. That is not self-defense. And you should not find the defendant not guilty because of that. What if you find that she does that because of Lilia? She's so angry about Lilia that she wants to get back at him. I have a gun too, David. Walks up the stairs, shoots. That's revenge, that's not self-defense. The judge is going to tell you that. And I want to talk about these. Because at the beginning of this case, Mr. Willis got up and he said, this case is about self-defense. That's what he said, right? But then what happened was he realized that self-defense ain't looking so good anymore. When you have someone who killed someone who's hiding behind a locked door and won't admit that she shot him in self-defense because she's going to double down on I'm trying to shoot this by aiming up here, self-defense isn't looking good anymore. So now we want voluntary or involuntary manslaughter. Just in case. Just in case you guys don't think that it was self-defense, just gonna slide this one on in there. Let's throw the spaghetti at the wall and see what sticks. Everything but the kitchen sink. In case you don't believe self-defense, we want to have a backup plan, B and C. Do not find the defendant guilty of voluntary manslaughter and involuntary manslaughter. And here's why. Voluntary manslaughter, the purpose of this statute is if, for example, someone walks in the room and their spouse is actively cheating on them and they already had a gun on them and they're just so immediately filled with rage they shoot the person. That is similar to voluntary manslaughter. Why is what happened in this case not voluntary manslaughter? Because it's only if the person acted on a sudden, only because of a sudden, violent, irresistible passion. What else is important about involuntary manslaughter? Time passing between provocation and the killing. Defense wants you to believe that because David was sending money to Lilia, that she was just so angry, so enraged that maybe you're gonna hopefully at least believe that she just killed him because of that. That's not voluntary manslaughter, ladies and gentlemen. 3 months had passed. Cooled off, this is the law. If someone has had time to cool off, it's not voluntary manslaughter. She's had 3 months of cooling off. She's choosing to stay with him, that's her choice. No one's making her do it. That doesn't mean that every time someone gets mad at a significant other and they can't get over it and months pass and they're hoping they can get over it and they can't, that they're allowed to kill them. Leave. Break up with him. The cooling off period. You can't find him guilty, her guilty of voluntary manslaughter if you find she had a cooling off period. She found out about Lilia in December. We're in March. Imagine, she cannot say, I was so angry at David and I just couldn't get past it and it was just so violent and irresistible passion inside of me and so I decided to kill him. You can't, that is not voluntary manslaughter, that is murder. That is, I was unhappy in my relationship and I couldn't move past it and instead of leaving, I just decided to kill him. What is involuntary manslaughter? Essentially causing the death without intending to by reckless conduct. Defense wants to relabel the aggravated assault where she walked up to the door, got 6 inches away, aimed in the direction of Mr. Barron and fired as reckless. Ladies and gentlemen, that's not reckless, that's assault. They want you to find her guilty of involuntary manslaughter by reducing what she did, by calling it reckless. That's not reckless conduct, ladies and gentlemen. That is aggravated assault. That is an intent to assault or put someone in reasonable apprehension of receiving injury. I'm gonna shoot you. I'm gonna shoot you. Fires the gun. That's not reckless. That is assault. Do not find the defendant guilty of involuntary manslaughter. It is a cop-out. They're trying to slide those in just in case their self-defense theory doesn't work, because it makes no sense. Hopefully you at least do that. Credibility of a witness. The judge is going to tell you this. Basically, it's your job to judge the credibility of every single person who got up on that witness stand. That's your job. You can do that by looking at the manner in which they testify or their lack of interest in the case or their interest in the case. So let's look at all the witnesses you heard from the state. All the officers have absolutely no interest in this case. They're just doing their jobs. Think about the manner in which they testified. Let's talk about Evan Barron, because they really attacked Evan. Mr. Willis really attacked Evan in his close. He said that Evan told you who the victim really is. I don't know what testimony that he was listening to when Evan testified, because what I heard Evan testify to about the night of December 28th is that she called him frantic, yelling that she pointed a gun at him, at David, that David got the gun away from her, that he was trying to leave, and that she had his keys and had locked herself in the closet or bathroom. It keeps going back and forth. I don't know which one it was at this point, because everyone said both. Closet or bathroom. And that he heard his dad yelling because he wanted to get his keys so he could leave. And then what Evan testified to was that after they made sure everyone was okay, that dad is safe at a hotel because she finally gave him his keys back, and after he made sure Suzanne was okay, he told Suzanne, we don't like this whole Lilia thing, we've known about it, we're gonna talk to him about it. This wasn't some intervention for the victim's anger and all these things that Mr. Willis was talking about. It was a complete misrepresentation of what Evan said. And Evan kept trying to correct him on the stand too. I vividly remember that. He kept saying, you were gonna have an intervention though with your dad after this, right? Yeah, an intervention about Lilia. We wanted to talk to him about Lilia because we didn't want him sending money to her. But an intervention, right? And then he just wrote the word intervention. Completely misrepresenting what Evan said in the testimony. Completely misrepresenting it. And then the whole spare key situation, did you see any keys on the counter? Evan said, clear as day, we found them in the junk drawer, in the pantry. I don't know why we were showing all this body cam to show that there were no keys sitting out on the counter. No one said that the keys were sitting out on the counter. He said they were in a junk drawer. They're just trying to make Evan look like a liar, and to be honest, of all the family members you heard from, Evan was the most honest. He has every reason to come in here and say all these horrible things about the defendant because she murdered his dad. But guess what he did? He told you the truth. I was happy for him. They had a lot in common. They liked football. Family vacation was great. We all got along. When you're judging the credibility of witnesses, part of what you're doing is judging the manner in which they testify. He had every reason to come in here and think of anything to say to shame her and to put her down because she killed his dad. And he told you the truth. We liked her. I didn't like the Lilia thing either. I wanted it to go away. I think the only bad thing he said about her was made me a little bit uncomfortable that she was reaching out to me that much about Lilia. That was it. How about Beth? Beth has known David for 50 years. Married him for 23.
50, God.
This defendant knew him for 10 months. Married for 23 years, has known him for 50, remained friends with him up until the day that he was killed. And what did she tell you? He was a peaceful, kind person. How about Laura?
She's fucked.
Married for over 10 years, friends for 25, remained friends up until the day he died. What did she tell you? Same thing. Let's talk about Dana and her kids. How about the manner in which they testified? The rehearsed robotic testimony you heard from them. How about the story that one of them said about the defendant being force-fed a bowl of ice cream by David? That was the example that they gave about how abusive he is. He gave her a big bowl of ice cream. They're trying to pull anything out. They don't want their mom to be convicted of murder, and I don't blame them. I don't blame them. They're her kids. They did nothing wrong. Dana did nothing wrong. It's her sister. But when you're judging their credibility, that's something for you to consider. The manner that they testified in and their interest in this case. How about Dr. Elcon? I really don't want to spend too much time on Dr. Elcon because I personally don't think it's worth it. Because everything she said was blowing my mind, if I'm being honest. Everything was consistent with Mr. Barron being an abuser, without any follow-up, without any verification. She just took the defendant's word for everything. She didn't even bother to get prior mental health health records of the person she's trying to diagnose with PTSD. Didn't even get mental health records. That is insane to me, ladies and gentlemen. That is insane to me. And there are hundreds of real victims of domestic violence that walk into this courthouse every single day. Hundreds. She owes every single one of them an apology. She is a disgrace to victims of domestic violence. She is an absolute embarrassment to real victims of domestic violence. So was Dr. Elcon. Because how dare she? I asked her, there's a literal picture of David with the scratch on his face, with the defendant admitting that they got into a fight and he scratched her, and she's like, oh, that was just a scratch. Imagine if there had been a picture with a scratch on her face, and what we would have heard about that. Imagine. Not even putting in her report that this defendant told her she had thoughts of suicide the night she murdered her boyfriend. Didn't think that was important to put in her report. Not putting in her report that this defendant told her allegedly that he made her basically perform oral sex on him the night that she killed him. She's diagnosing her with PTSD for trauma that Mr. Barron inflicted on her allegedly, and she didn't think it was important to put in her report that the night that he was killed, he forced her to perform oral sex on him. How was that not important for your report? First time I heard about it was in opening statements because it wasn't in her report. First time I heard about the suicide was in opening statements because it wasn't in her report. Jim Persinger is very impressive. He is a very credible witness. He is very impressive, and I do not think he got up there and lied to any of y'all. I just put him up in this slide because I didn't really understand the purpose of his testimony. I didn't really see how it was relevant because the phones went up the stairs 12 seconds apart. He attributes that to a glitch, or not a glitch, but a lag in the phones. How do we know that they didn't just go up the stairs 12 seconds apart? He's just making an assumption. Could have gone up the stairs 5 seconds apart. Also, it doesn't really matter if the phones went upstairs at the same time because we don't know who took them up the stairs. Could have been her. Didn't tell us anything. How about the credibility of the defendant? I think I've talked about it enough, so I'm going to breeze through the fact that this defendant is a compulsive liar. But these are all the lies that I could just think of on the top of my head that we know for an absolute fact are not true. We know that David didn't shoot at her, regardless of how many times she said he did. We know she flushed shell casings, regardless of how many times she said she didn't. We know she fired his gun. We know he wasn't drinking. We know that that gun was not next to his body. We know that the holster was not next to his body. And we know that that whole kitchen store was a total lie. What about the fake ER visit? She was lying to y'all about that till we took a break, and then she gets back up on the stand, and all of a sudden, oh yeah, I'm sorry, that was a lie. Because she'd been caught. Couldn't lie about that one anymore. How about the fake man? Tried to lie about that at first, then realized she'd been caught with that too, so then she gave up on that one. Fake law enforcement coming to talk to her at St. Simon's. She's manipulating him. Imagine if Mr. Barron had done that and texted Suzanne, oh, I'm vomiting up blood, come see me. Oh my gosh, the things we would have heard from Dr. Elcon about that. I want to talk to you about this. Mr. Willis barely touched on it, probably because it makes absolutely no sense and no one really knows what to make of it. She wants you to believe that those shots from 12 to, that is a foot. This is 12 inches off the ground. It's from her committing suicide. In what world, with a gun like this, was she laying on the ground? Was she sitting on the ground? She had no blood on her back. She had no blood on her butt. How was she 12 to 16 inches off the ground with a gun like this, tries to fire it once, Oh no, it didn't fire. Tries to fire it a second time. Oh no, it didn't fire. Tries to fire it a third time. On the third time, oh! Oops, let me try again. Oh! In what world does that make any sense? That is the most insane thing. She didn't even really go into detail about how she did it because I don't think she knows to this minute how to explain how those shots fired from 12 inches off the ground were from an attempted suicide. But she wants you to believe that that's the reason why she fired David's gun out the door and why she flushed the shell casings, because she didn't want anyone to know that she sat here and just continuously did that. I want to show you the verdict form very quickly. Judge, may I have the, This is what the verdict form is going to look like. You're going to have it as well. And I want to show you and explain so you're not confused because there's a lot of options. This is count 1, malice murder. To put an X right here, you would have to believe either that the state did not meet all of its elements, which we have, which means the only other reason you would put an X here is if you find that the defendant acted in self-defense and was justified in killing Mr. Barron. That's the only reason to put an X right there. If you find that she maliciously killed the defendant, intended to kill him, this is where you put your X. Line 2. Every count, line 2 is going to be what the defendant is charged with in the indictment and what the state is going to ask that you find the defendant guilty with beyond a reasonable doubt. Line 2, malice murder, guilty. On to count 2. This is the felony murder based off of aggravated assault. Guilty. What are these below it? These are their plans B and C. This is the, oops, self-defense doesn't really make any sense. Hopefully maybe they do manslaughter instead.
Judge, I have to object. I've allowed her to state this many times. The charges are from the court, not from the defense, so I'd ask her not to make that inference. I object.
I don't think there's anything improper about this, Judge. They asked for them to find the defendant guilty of voluntary manslaughter, involuntary manslaughter, and I'm asking them not to.
I most certainly did not.
Without commenting on the evidence, the state is welcome to give their opinion on what they would like for the jury to cross-check, whatever. That's perfectly reasonable. Without commenting on the evidence, the court has created the documents that are being referenced, and it's the court's, again, not making any comment one way, but it's the court's document with input from the parties with ultimately my final. So I will overrule the objection with that explanation. State may proceed.
Thank you, Judge. Sounds like they're not asking you to find her guilty of voluntary manslaughter, involuntary manslaughter, so that makes that a whole lot easier for y'all then. Count 3, guilty of felony murder based off of the criminal damage in the first degree. Again, the second line on the verdict form. Count 4, again, only this if you find the state has not met the elements beyond a reasonable doubt or self-defense. If not, we move on to aggravated assault. What's below it is reckless conduct. Again, a lesser included that the defendant is not charged with. This is a cop-out. This is what the state's asking you to find the defendant guilty of. Count 5, first degree damage, criminal damage, property in the first degree. Second line, again, reckless conduct is their plan, is a plan B. And lastly, the last two. There's no other options other than guilty or not guilty as to counts 6 or 7.
laptop.
Yes, please. Ladies and gentlemen, any which way you spin this case, the defendant is guilty. There's no excuse, there's no justification, and there's no defense for walking up to a door, getting 6 inches away, and killing someone who's hiding behind it. And on top of that, her actions after the fact show why this was malicious and why there was intent. Because not only did she kill Mr. Barron, but then, while she stepped over his dead body, she altered the scene. She tampered with the evidence. She planted evidence. That is malice. After everything you've heard in this case, there is no room left for any doubt. There's just not. And at the beginning of this trial, Mr. Willis did. He put that picture up, the smiling selfie of the defendant on the beach, and he said, "You're never going to get to meet her. You're never going to get to hear from her. She's gone." And then you know what he just said? She's gone almost as much as James Barron. That is insulting. She's sitting right there. She got to see her kids yesterday. She got to see her smiling kids. They got to see her. Guess who you didn't get to meet? Guess who you're never going to get to meet? Guess who's never going to get to see his smiling kids? And his kids are never going to get to see him. You are never going to hear from him. He is never going to get to come in here and defend himself from her lies. She took that right from him, and she took the privilege from you to hear from him. You will never get to meet James Barron. There's only one victim in this case, ladies and gentlemen. And I promise you it's not the person who took a gun, brought it up, and shot through a locked door at someone hiding behind it. That's not the victim. This is the victim. He might not ever have the opportunity to come in here and tell his side of the story, but fortunately for Mr. Barron, the evidence speaks louder than he probably ever could have. And so, that's where you come in, ladies and gentlemen, that's where you come in. Because even though David's voice was taken from him by her, your verdict can speak volumes for him. So I'm going to ask that you follow the evidence, you ignore the lies, and you find this defendant guilty. Thank you.
In a few moments, I'm going to begin reading the jury instructions. If any members of the gallery wish to depart, I ask that you do that now. Parties, I ask your assistants, can we put the door somewhere other than right there? And I don't know if y'all need gloves. If you want to lay it down, that's fine. I just don't want to have it in the field of view while I'm reading instructions. Thank you. Members of the jury, I trust that you are comfortable for the next 20 to 30 minutes. Is that a fair assumption? Thank you. Thank you to the parties. I appreciate your assistance. Thank you.
Waiting for verdicts. What's the verdict?
Give everyone about 20 seconds more. You are considering the case of the state of Georgia versus Suzanne Renee Miracle. A grand jury has indicted the defendant with 1 count of malice murder, 2 counts of felony murder, 1 count of aggravated assault, and 1 count of criminal damage to property in the first degree, 1 count of possession of a firearm during the commission of a felony, and 1 count of tampering with evidence. The indictment reads as follows. Count 1. In the name and behalf of the citizens of the state of Georgia, charge and accuse Suzanne Renee Miracle with the offense of malice murder. 4, that the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did unlawfully and with malice aforethought cause the death of James Barron, a human being, by shooting him in violation of Official Code of Georgia 16-5-1 parentheses A close parentheses contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2. In the grand jurors aforesaid, in the name and behalf of the citizens of the state of Georgia, charge and accuse Suzanne Renee Miracle with the offense of felony murder. For that, the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did, while in the commission of a felony, to wit, aggravated assault as alleged in count 4 of this indictment, caused the death of James Barron, human being, in violation of Official Code of Georgia 16-5-1 parentheses C close parentheses contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3. The grand jurors aforesaid, in the name and on behalf of the citizens of the state of Georgia, charge and accuse Suzanne Renee Miracle with the offense of felony murder. For that the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did, while in the commission of a felony, to wit, criminal damage to property in the first degree as alleged in count 5 of this indictment, caused the death of James Barron, human being, in violation of OCGA 16-5-1 parentheses C close parentheses contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4. The grand jurors aforesaid, in the name and behalf of the citizens of the state of Georgia, charge and accuse Suzanne Renee Miracle with the offense of aggravated assault. For that the said accused in the county of Hall and the state of Georgia on the 8th day of March 2025 did assault another, to wit, James Barron, with a deadly weapon, to wit, a firearm, which when used offensively against a person is likely to and does result in serious bodily injury by firing said weapon through a door in the direction of James Barron in violation of OCGA 16-5-21, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 5. The grand jurors aforesaid, in the name and on behalf of the citizens of the state of Georgia, charge and accuse Suzanne Renee Miracle with the offense of criminal damage to property in the first degree. 4, that the said accused in the county of Hall and the state of Georgia on the 8th day of March 2025 did knowingly and without authority interfere with a door in a manner so as to endanger human life by shooting the door of a room that was occupied by a person, to wit, James Barron, in violation of OCGA 16-7-22, again 16-7-22, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 6. The grand jurors aforesaid, in the name and on behalf of the citizens of the state of Georgia, charge and accuse Suzanne Renee Miracle with the offense of possession of a firearm during commission of a felony, for that the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did have on her person a firearm, to wit, a handgun, during the commission of a crime, to wit, aggravated assault, as alleged in count 4 of this indictment, in violation of OCGA 16-11-106, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 7. The grand jurors aforesaid, in the name and behalf of the citizens of the state of Georgia, charge and accuse Suzanne Renee Miracle with the offense of tampering with evidence, for that the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did knowingly conceal physical evidence, to wit, shell casings and bullets, with intent to obstruct the prosecution of said accused in violation of OCGA 16-10-94, contrary to the laws of said state, the good order, peace, and dignity thereof.
It's a lot of charges, bro.
The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent unless and until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in the defendant's favor. This presumption remains with the defendant until it is overcome by the state with evidences sufficient to convince you, beyond a reasonable doubt, that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime as charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you should find the defendant not guilty. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to find the defendant not guilty. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is a testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A statement that the defendant allegedly made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestion or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. You may consider the duration and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant had a right to remain silent. 2, if the defendant chose to not remain silent, anything she said could be used as evidence against the defendant in court. 3, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with her at all times during any questions. And 4, if the defendant did not have money for a lawyer would have been provided for her to represent her before any questioning and to be present with her during any questions. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or part of such evidence. If you fail to find that the defendant was properly informed of these rights and that she understood and gave up, I will start over. If you fail to find the defendant was properly informed of these rights and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. Evidence of prior difficulties. or lack thereof, between the defendant and the alleged victim or a witness has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim or witness, or the reasonableness of any alleged fears by defendant or alleged victim. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act or omission to act and intention. When the indictment charges that a crime was committed in more than one way, the state is not required to prove the commission of that crime in every way, but may prove the crime was committed in any of the ways charged. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Criminal negligence is an act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Hall County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt. As to each crime charged in the indictment, just as any element of the offense or offenses, venue must be proved by direct or circumstantial evidence or both. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe, beyond a reasonable doubt, that the defendant in Hall County, Georgia, did, on or about March 8, 2025, commit one or more of the offenses of malice murder, felony murder, aggravated assault, criminal damage to property in the first degree, possession of a firearm during commission of a felony, and or tampering with evidence as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. For each count, you find the defendant guilty. If you do not believe that the defendant is guilty of any or all of the offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. For each count, you find the defendant not guilty. Your verdict should be a true verdict, based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, without excuse, and without mitigation. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Felony murder. The state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony, which I will define for you shortly. Criminal damage to property in the first degree is a felony, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that she caused the death of another person by committing the felony of aggravated assault and/or criminal damage to property in the first degree, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. In considering the malice and felony murder charges in counts 1, 2, and 3, you must first decide whether the defendant was sufficiently provoked and acted out of passion. If you find this, you may not return a verdict of guilty of malice or felony murder, but you would be authorized to return a verdict of guilty of voluntary manslaughter.
That's a play.
The state must prove beyond a reasonable doubt that the offense should not be reduced from murder to voluntary manslaughter. The defendant may not be guilty of malice murder in count 1 or felony murder in counts 2 or 3, but still guilty of voluntary manslaughter. For voluntary manslaughter, the evidence must prove that the defendant, 1, caused the death of another person, 2, under circumstances that would otherwise be murder, 3, and acted only because of a sudden, violent, and irresistible passion that resulted from serious provocation. 4, which was sufficient to excite such passion in a reasonable person. If you decide that enough time passed between the provocation and the killing for a reasonable person to have cooled off and regained judgment, then the killing is not voluntary manslaughter. If you find that the defendant acted under such provocation and passion as would authorize a verdict of voluntary manslaughter as to count 1, you would not be authorized to find the defendant guilty of felony murder based upon that same aggravated assault as to count 2, or first-degree criminal damage to property as to count 3. You would, however, be authorized to consider whether the defendant is guilty of voluntary manslaughter as to count 2 and or count 3. If you find that the defendant acted under such provocation and passion as would authorize a verdict of voluntary manslaughter as to count 2, you would not be authorized to find the defendant guilty of malice murder based upon the same aggravated assault as to count 1, or first-degree criminal damage to property as to count 3. You would, however, be authorized to consider whether the defendant is guilty of voluntary manslaughter as to count 1 and or count 3. If you find that the defendant acted under such provocation and passion as would authorize a verdict of voluntary manslaughter as to count 3, you would not be authorized to find the defendant guilty of felony murder based upon the same aggravated assault as to count 2, or that same aggravated assault as to count 1. You would, however, be authorized to consider whether the defendant is guilty of voluntary manslaughter as to count 1 and or count 2. Words alone, no matter how provoking, will never reduce the crime from murder to voluntary manslaughter. However, words coupled with menacing actions, even if they do not amount to physical contact, may be enough to excite a sudden, violent, and irresistible passion in a reasonable person. If you find that the defendant acted from such passion and not from malice or any spirit of revenge, then you would be authorized to return a verdict of guilty of voluntary manslaughter. The defendant may not be guilty of malice murder in count 1 or felony murder in counts 2 or 3, but still guilty of involuntary manslaughter. 4, involuntary manslaughter, the evidence must prove that the defendant, 1, caused the death of another person, 2, without intending to, 3, by committing the offense of reckless conduct. If you find that the defendant acted without such intent as would authorize a verdict of involuntary manslaughter as to count 1, you would not be authorized to find the defendant guilty of felony murder based upon that same aggravated assault as to count 2, or first-degree criminal damage to property as to count 3. You would, however, be authorized to consider whether the defendant is guilty of involuntary manslaughter as to count 2 and or count 3. If you find that the defendant acted without such intent as would authorize a verdict of involuntary manslaughter as to count 2, you would not be authorized to find the defendant guilty of malice murder based upon the same aggravated assault as to count 1, or first-degree criminal damage to property as to count 3. You would, however, be authorized to consider whether the defendant is guilty of involuntary manslaughter as to count 1 and or count 3. If you find the defendant acted without such intent as would authorize a verdict of involuntary manslaughter as to count 3, you would not be authorized to find the defendant guilty of felony murder based upon that same aggravated assault as to count 2, or that same aggravated assault as to count 1. You would, however, be authorized to consider whether the defendant is guilty of involuntary manslaughter as to count 1 and or count 2. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon or an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. A person commits the offense of criminal damage to property in the first degree when she knowingly and without authority interferes with any property in a manner so as to endanger human life. The term without authority means without legal right or privilege. The defendant may not be guilty of aggravated assault in count 4 of first-degree criminal damage to property in count 5, but still be guilty of reckless conduct. For reckless conduct, the evidence must prove that the defendant, 1, caused bodily harm to another person, 2, by consciously disregarding, 3, a substantial and unjustifiable risk, 4, that the defendant's act, 5, would cause harm to the other person. A conscious disregard must arise to the level of a gross deviation from the standard of care a reasonable person would exercise in the particular situation. For possession of a firearm during commission of a felony, the state must prove that the defendant, 1, had a firearm, 2, on her person, 3, while committing an aggravated assault. For purpose of this offense, a firearm includes any handgun. A person commits the offense of tampering with evidence when, with the intent to obstruct the prosecution of any person, she knowingly conceals physical evidence. The defendant has raised a defense that even if she committed the act described in the indictment, there are circumstances that justify it. Once this defense is raised, the state must disprove it beyond a reasonable doubt. If a defendant's conduct is justified, that is a defense to any crime based on that conduct. Sometimes a defendant's threat or use of force is legally justified and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when, 1, she reasonably believes that the use of such force is necessary. 2, to prevent A, death or serious bodily injury to herself, or B, the commission of a forcible felony, which means a felony that involves the use or threat of force or violence against another.
And the judge, I feel like they just
aggravated assault by strangulation, aggravated sodomy, and malice murder are forcible felonies, each of which I will define for you shortly. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. Aggravated assault by strangulation is an attempt to injure another person with anything when used offensively is likely to or does result in strangulation, including one's hands. Strangulation means blocking or interfering with another person's normal breathing or blood circulation by either 1, applying pressure to the person's throat or neck, or 2, obstructing the person's nose or mouth. Sodomy is any sexual act that involves the sexual organs of one person and the mouth or anus of another. Aggravated sodomy is an act of sodomy that is both forcible and against the will of the victim. An act is forcible if it is accomplished through acts of physical force, threats of harm, or intimidation. An act is against the will of the victim if it does, I repeat, an act is against the will of the victim if it is done without the victim's consent. For the defendant's threat or use of force to be justified, 1, the defendant must believe that her threat or use of force is necessary. 2, that belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary, and the defendant's reasonable belief must be what prompts her to threaten or use force. A person who is not the aggressor is not required to retreat before being justified in using force she reasonably believes to be necessary. The defendant's use of deadly force may be justified even when there has not been physical contact between anyone, if the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's life is in imminent danger. The defendant is in imminent danger of serious bodily injury, or a forcible felony is about to be committed. Then, the defendant's use of deadly force may be justified. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, Verbal threats accompanied by some menacing actions may justify the use of deadly force. A defendant is not justified in using excessive force while acting in self-defense. If you decide that the defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. A defendant is not justified in threatening or using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. If you find beyond a reasonable doubt that the defendant used force against the alleged victim for the purpose of avenging a past wrong and not for the purpose of preventing an imminent commission of a forcible felony, then you would be authorized to convict the defendant. A forcible felony is a felony that involves the use or threat of force or violence against another. Aggravated assault and aggravated sodomy are forcible felonies and will be defined for you shortly. If a defendant raises as defense justification using force against another, you may consider relevant evidence that the defendant has been subject to acts of family violence or dating violence in order to establish the defendant's reasonable belief that deadly force was immediately necessary. Family violence means the occurrence of one or more of the following acts between persons living in the same household. 1, any felony. Or 2, commission of offenses of battery, simple assault, stalking, criminal damage to property, unlawful restraint, or criminal trespass. Dating violence means the occurrence of one or more of the following acts between persons who are currently or within the last 12 months were in a dating relationship. 1, any felony, or 2, commission of the offense of simple battery, simple assault, or stalking. Dating relationship means a committed romantic relationship characterized by a level of intimacy that is not associated with mere friendship or between persons in an ordinary business, social, or educational context. Voluntary intoxication is not a defense to a crime. If the defendant, when sober, could reason and distinguish between right and wrong, and she voluntarily became intoxicated and then committed a crime while intoxicated, she is responsible for the crime just as if she had been sober at the time she committed the crime. Members of the jury, by no ruling or comment that the court has made during the progress of this trial has the court intended to express an opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. You are only concerned with guilt or innocence of the defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to select one of your number to act as a foreperson who will preside over your deliberations, and he or she will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change your opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of opinions of other jurors. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. You will have with you all the evidence which has been introduced at trial. Additionally, you will have a copy of the indictment, this charge of law, and the verdict form. This has been displayed, making no comment on that display, but you will have a copy of the verdict form. You will mark your verdict for each and every count, marking one and only one option per count. It will then be signed and dated by your foreperson. Once you have that verdict, please let the bailiff station outside your door know. We will get you into court as quickly as possible in order to take that verdict. In a moment, you will retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence which has been admitted in this case. During that time, you may proceed to select one of your foreperson as your foreperson. Other than previous objections, any reading that y'all would like to discuss? If you do, approach.
Approach now, or forever hold your peace.
Everybody makes mistakes, including judges. I'm going to reread one charge, and just because I'm reading it doesn't mean I'm necessarily focusing on that, but I do want to make sure that it is correct. This is in relation to causation in felony murder. I'm going to reread it. You may find the defendant guilty of felony murder if you believed that she caused the death of another person by committing the felony of aggravated assault and or criminal damage to property in the first degree, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of whether the death ultimately occurred. Good?
Yes, Your Honor.
I apologize for that. Any other reading things we need to discuss?
Not from the state judge.
Nor from the defense.
Folks, I'm aware that it's 1:10. You are going to control your own schedule. There are currently 14 of you. I will discuss with the two alternates. They've not done anything wrong. All 12 of you will deliberate. If someone needs to take a break, you all take a break. You cannot start without somebody. So if somebody disappears on us, then we'll restart with an alternate. You will control your schedule. So certainly want y'all to make a reasonable effort at it. If you would like to go break for lunch now and come back, y'all figure that out. If you would like for the county to purchase lunch for you while y'all work, we can make that happen. That's an either or. So we're going to leave it to you. The attorneys and I have discussed the door. We will move that into your jury deliberation room. If y'all do not want it there, let one of the bailiffs know and we'll work on getting it out, et cetera, et cetera. Making no comment one way or the other, you will have with you all the evidence as well as gloves, if appropriate, regarding handling. You will not have with you a computer or some way to play video and or audio. So if you, I'm not saying you should or should not, but if you do desire to do that, you'll have to affirmatively request and then we'll bring it out and play it, etc. With that, I will leave you to go deliberate. I will briefly discuss with the two alternate jurors, Eubanks and Render, please. Everyone else can go to the deliberation room. We will need a decision on whether you want a break. You can take breaks, just give us the courtesy of letting the bailiffs know. Thank you.
I think we back to clapping shit. Just boy. Boy, oh boy, oh boy, oh boy, oh boy.
For purpose of discussion with the alternate, I'm going to mute the live stream.
Tomorrow we probably on 2K. We gonna bring it back to the roots. Let's go. Let's get it. They don't know that I'm really with it. I pulled up, banging, I'm topping. I need to.
Reload! Reload!
I need one more gun as well.
Is this a raid? How rude. Woo! Nailed it! I just sent the enemies packing.
Loadout airdrop incoming.
The enemy is here. This isn't fun.
The safe zone is shifting.
Reload! Reload! Woo! Nailed it! Reload! Reload! I just sent the enemies packing. Meds here.
Need to wash my hair, jeez. This remind me of Fortnite.
Oh, what a loser!
I don't know why they always want to shoot and then run away.
defined.
Where the fuck did he run to? Thought it's supposed to be a body, y'all.
The safe zone is shifting.
I can't drive with the joystick though.
Reload! I just sent the
Mega
enemies
kill!
packing. Reload! Enemy is here! This isn't fun!
The new
Striker! A striker! Using bandage.
The safe zone has been redefined. Loadout airdrop incoming.
The enemy is here!
Where does he-
This isn't fun!
I'm coming right back. Where did I die? Right over there. I see him trying to run.
The safe zone is shifting.
Reload! Is this a raid? How rude! Using bandage.
The safe zone has been
That was
redefined.
bullshit. He got lucky as a fucking safe zone.
wasn't fun.
I ain't had no gun. I respect it though.
Have a plan on evidence, so we'll talk about that in a moment. Anything else that y'all want to talk about before we talk about evidence?
Not like they have judge.
I just want to make sure that the charge of the course that you identified as
C1
is going to go back along with
Sorry.
the
No. To clarify, C1 will remain with a court reporter. That's a duplicate original. This is what I'm going to hand to the chief bailiff, and if y'all would like to inspect it, that's fine. On the jury verdict form, there's nothing on there other than what we agreed. Jury instructions, there's nothing on there. That's inadvertently folded. I don't think that's on page 10. I don't think it indicates anything. And then we have the indictment, which I don't know who did it, but somebody wrote the case number, not me, on various different pages, which I don't think influences one way or the other. But y'all can inspect that. That'll be going back to the 12 assembled jurors.
Yeah. Yeah. I'm interested. Thank you. You said 149?
Thank you.
Oh, I have,
Any other issues other than evidence?
Not the most.
oh, sorry. No, not from the state judge.
Okay, so what do we want to do? Is it vacant now?
Yes.
So the deliberation room is vacant now. Do y'all want to have somebody other than me take the door in and place it?
Yeah, I spoke with the deputies, about if they wanted to, I don't know if they want us to put it in the bag and then we carry that way, or if they just
All right,
want to
I
carry
don't
the
know what's
door
going
as
on.
is. I mean, it's opposite the deputies.
I don't know what's going on. We back to this.
The safe zone has been
I
redefined.
jump on today real quick. I gotta hit up on some humbug shit, Scott. Damn near punched the mic down. Goddamn.
The
Be
safe
careful.
zone has been redefined.
You see my dude just standing there? That's gangsta. Going to the hotel. I ain't gonna lie, I thought I was talking about the land on the letters. God, one of them RPK, that shit held a hundo. Like that. I mean, that was a little good spot to land, keyword.
Loadout airdrop incoming. The safe zone is shifting.
I don't know where it's on that. Oh, that was not part of the plan. Where is this nigga?
Woo! Nailed it! Reload, reload! Reload!
Chasing something for so long. Oh, shit.
Oh, what a loser!
The safe zone
Reload,
has been
reload!
redefined.
I think I should have kept that heavy gun. Got one.
Reload, reload! Is this a raid? How rude! Oh, what a loser!
The safe zone is shifting.
It's crazy how footsteps is getting, bro. And son is walking with you. You don't pay attention. You will be caught slipping. How do you change that thing?
Weapon here. Go check over there.
Loadout airdrop incoming. The safe zone has been redefined.
Oh, what a loser!
The safe zone is shifting.
Oh, I'm the new ace striker! Ace striker! Reload, reload! Is this a raid? How rude!
Wicked
Reload, reload!
Wicked sick!
Oh, what a
Safe
loser!
zone has been redefined.
Oh my god, I fucking saw it.
Woo! Nailed! Reload, reload! Reload, reload! Oh, what a loser! Enemy is there!
Double kill.
Reload, reload!
The safe zone is shifting. Wicked
I'm the
sick!
new ace striker! Reload, ace striker!
Double kill. Wicked sick!
Tell me. Tell me. Claim 3. Should open it. Nifty 50. So reds is announcements. Yellows is stuff that's supposed to grab. They looked up though. 3 days, I'd rather take the low 1,000, whatever those is. I feel like I could just buy some. Oh, is this how I switch them? Or the meat is it? Definitely not. I see shit like these. Nah, we cool on that. That's the use of that. Pretty good. Got everything. I'm gonna change my card. Oh. Thank you for supporting Blood Strike. No, I did that. Say that. Sour lime joint, you heard? Bluesdale sour lime, you know, nothing too crazy. Wow. Oh, I got 49.
I mean, if they want to look at it, then whatever y'all decide.
As long as the deputies are okay with just picking it up and carrying it back there, I'm fine with that. We can, there's the stand, I mean.
I shall do right back. Your boy gotta use bug. Oh. Everybody that's typing in on the Twitch, YouTube, and the Rumble. Shout out to everybody again. Shout out to everybody. Right back, y'all.
zone has been redefined.
Reload! Is this a raid? How rude! Is this a raid? How rude. Enemies here. Go check over there. Give them a surprise. Reload!
The safe zone is shifting.
Reload!
Loadout airdrop incoming.
Reload! The enemy is here! This isn't fun! Ooh, nailed it! Reload! Oh, what a loser! I'm dying!
The safe zone has been redefined.
The enemy is here! This isn't fun! Nailed it!
The safe zone is shifting. The safe zone has been redefined. The safe zone is shifting. The safe zone has been redefined.
Nailed! Reload, reload! This isn't fun. I'm dying.
Loadout airdrop incoming.
The enemy is here. This isn't fun.
find.
Is this a raid? How rude.
Loadout airdrop incoming.
Woo! Nailed! Is this a raid? How rude. Packing.
The safe zone is shifting.
Reload, reload! Nailed! Reload, reload! Oh, what a loser!
Double kill.
Reload, reload! Reload, reload! Reload, reload! Reload, reload!
The safe zone has been redefined.
Is this a raid? How rude!
Mega
I'm
kill!
the new ace striker! Ace striker! Using bandage. Reload, reload!
The safe zone is shifting.
Reload, reload! I just sent the enemies packing!
Unstoppable! The safe zone has been redefined. Loadout airdrop incoming.
Woo! Nailed it! Reload, reload!
The safe zone.
This isn't fun!
The safe zone is shifting.
Is this a raid? How rude!
Mike Keppel here, Patriot Software's founder. Want to hear something odd? Why would an accounting and payroll software company
Don't stop.
near a narrow doorway.
Contribution from entrepreneur and activist Paul English, who is also a BPS grad. And BPS will work with UMass Boston's Paul English Applied Artificial Intelligence Institute to develop the course. Students. $7 billion.
Harp has re-entered the courtroom to announce his verdict. Let's listen in.
To our audience members. I understand that this case has generated a lot of passion and emotion, but you must remember that this is a courtroom and not a sports arena. When I announce my verdict, you must not act out emotionally or visibly or audibly react. So you should leave the courtroom if you believe that you will be unable to maintain your composure. I'd like to start with a few introductory words.
Oh shit!
Let me say
Here we
this,
go again.
This is not in my script. This has been one of the more exhausting, hardest things I've had to do as a judge, as an attorney. And in any event. So, as the lawyers know, unlike when a judge presides over a jury-waived trial in a civil case, there is no requirement that a judge explain their reasons for reaching a verdict after a criminal bench trial. I do so in this case because I think that Ms. Fitzsimmons, Officer Noonan, and all the people involved in the tragic events of June 30, 2025 deserve an explanation. Next, I'd like to take the opportunity to publicly thank and commend the attorneys in this case. They all did an exceptional job presenting the evidence and conducting themselves in an extremely professional and civil manner. And they did so under the public spotlight in an emotionally charged case. I commend you. To the extent that any of the prosecutors and attorneys may be vilified or subjected to public scorn for simply doing their jobs, in this case, I say that any such scorn is unfair, unwarranted, and simply wrong. These prosecutors and attorneys fought hard, but performed their solemn jobs fairly with the utmost civility, and professionalism. They served as a shining example of our adversarial system in operation. Now, I'd like to publicly acknowledge the crucial and often thankless role that police officers perform, a role that Ms. Fitzsimmons herself, like Officer Noonan, willingly and selflessly performed for the citizens of North Andover. For this, you should be thanked, not disparaged. For those that think that serving as a police officer is easy, or that officers don't care or take pride in their work, I say with more than 3 decades of experience in the criminal justice system that you are naive, misinformed, and sadly mistaken. The work of police officers is especially fraught with peril today because of our exceedingly cynical, polarized atmosphere where our citizenry often believes that there is a conspiracy under or around every corner. I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants like Officer Noonan and his fellow officers doing the best they could under tragic, rapidly evolving emotional circumstances. What I also saw was a young woman, Ms. Fitzsimmons, who was also a dedicated public servant, react to sudden, confusing, and heartbreaking news. Now let me turn to the evidence and the law. Our system of justice requires me to decide this case solely on the law and the evidence. So the only things I have considered in reaching my verdict are the 98 exhibits admitted during the trial and the testimony of the 11 witnesses that testified here in open court. While it may be cold and uncaring, our system of justice demands that emotion, sympathy, and concern for the consequences of my decision play no role in my decision. As for the law, in order to prove Ms. Fitzsimmons guilty of the crime of assault by means of a dangerous weapon, the Commonwealth must prove the following three things. We lawyers call these things elements beyond a reasonable doubt. First, that Ms. Simmons committed an assault on Officer Noonan. Second, that Ms. Simmons intended to commit the assault. And third, that the assault was committed by means of a dangerous weapon. The sole issue before me is whether the Commonwealth proved each of these three elements beyond a reasonable doubt. And more specifically, under the circumstances of this case, the narrow issue before me is whether the Commonwealth proved beyond a reasonable doubt that Ms. Fitzsimmons pointed a firearm at Officer Noonan for any perceptible amount of time. What is not before me are the legality of the issuance of the restraining order to Mr. Alain, the reasonableness of the procedure used by the police to serve the restraining order, the legality of Officer Noonan's use of force, and issues regarding the custody of Caden. It is not my place to decide these issues or even mention my thoughts on them. I am thankful for this because my role has been hard enough. What has made my job especially difficult in this case is that by and large, I found the testimony of Officer Noonan and Ms. Fitzsimmons to be credible on the material and relevant points. In my experience, this is unusual and somewhat perplexing. On the one hand, Ms. Fitzsimmons credibly testified that she never pointed a firearm at Officer Noonan. On the other hand, Officer Noonan testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agree that it happened in seconds near a narrow doorway, and the crime scene photos show that the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Noonan's left. The door frame was also made, strike that, the door frame was made still narrower when Officer Noonan used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever racking the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those circumstances. However, even if I assume that Ms. Fitzsimmons lied about not racking the slide, it does not detract from the adamancy and credibility of her testimony that she never pointed the gun at Officer Noonan, about which he was equally as adamant that she did. Perhaps the Commonwealth could have easily met its burden if the officers had been wearing body cameras. But under these circumstances,
Dog grooming genius here. No, over here. And I live for operational excellence. Cute makeup.
the Commonwealth has not met its burden to prove that Ms. Fitzsimmons committed an assault by means of a dangerous weapon on Officer Noonan, and my verdict is and must be not guilty. With that, I will hand the signed verdict slip. Did I lose it? I will hand the signed verdict slip to Mr. Ruane, and ask that he advise Ms. Fitzsimmons of her statutory rights.
Ms. Fitzsimmons, could you please stand? On docket 2025, 77 CR 311, count 001, the court having returned a verdict of not guilty, the court orders that you be discharged of this indictment, and this indictment only, and go thereof without delay. Kellsey Fitzsimmons, as required by statute, I must inform you that the records regarding the charges for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you may use the request not to seal form posted on the trial court's webpage on mass.gov, or a copy of which I will hand to your counsel. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Do you understand?
Yes, I do.
Thank you.
Thank you. Court is in recess.
Good, all rise. Please exit quietly, and thank you once again.
There you have it, a not guilty decision by the judge in the Kellsey Fitzsimmons trial. You see Kellsey right there with her lawyer, right there giving him a hug. She is now free to go. The records will be sealed, and she moves on to the next phase of her life. The key here, Glenn, I thought, was that the judge said both sides were credible. He believed both sides, and that possibly this all could have been solved with body cameras. He threw that in at the end. Body cameras would have avoided this trial altogether.
Yeah, that was an important note from the bench.
Crazy.
You see the gallery filing out there, including Officer Noonan there in the
Spicy.
blue
You hear me?
jacket. The courtroom was packed for this verdict, a bench trial, so a jury did not hear the evidence, only the judge. Let's bring in NBC 10 Boston legal analyst Michael Coyne. Michael, let's start the conversation with what JC just mentioned. The judge said that he found both Noonan's and Fitzsimmons' testimony credible, but we have to also acknowledge that their testimony conflicted. So parse that for us. How can both things be true?
Well, I think, we talked about it just at the end last night. It's a matter of perception. And I do think that that's what really, at the end of the day, one could align both of these versions of the events, is that Officer Noonan believed one thing was taking place as she moved that gun in some fashion, while her version of the events is, her truth is that if I was moving it at all, and I was, it was towards my own head, not towards someone else. And we have to remember how quickly these whole things happen, and that's why the judge made reference to the narrow doorway, the door in the way, and these big bodies in a relatively small cape, so that you really don't have a lot of time to see everything that's going on, and you don't have a lot of time that we all get to act in hindsight and say, well, maybe this should have been done or that should have been done.
One thing, Michael, that we heard right at the start from Judge Karp was he said this was exhausting and the hardest thing he's ever had to do. Can you explain that perspective? It was a quick trial. It didn't seem overly taxing or dramatic, and yet, he's had an extensive career, so to say that is quite a statement.
Oh, sure. People don't understand how mentally and physically draining it is to actually try a case, because it's not just the 3 days or 4 days now that you've spent in actually sitting there listening to the arguments and the rest. It's all the preparation time. Again, you see these trials on TV and Law and Order and the rest, and everything's done in an hour. The preparation that goes into the cases of this sort by the lawyers are likely well in excess of 1,000 hours, and the judge needs to be prepared as well. And as I think we all could see throughout the course of the trial, he knew the law, he knew the facts of the case, he understood where the pleadings were at and where the discovery was. That's an intense amount of work, and especially then when that has to all be done under the glare of the media, everyone inspecting and micro-managing every little move that not just the lawyers make, but the judge makes as well. It is very physically and mentally exhausting at the end of the day. And I think that's all he was conveying to the rest of us, is that, he's tired. He needs a couple of days at the beach himself.
We're just watching Kellsey Fitzsimmons, the defendant in this case, leave the courtroom. We expect at some point she will speak to the media. If that happens here in the next few minutes, we will bring it to you live. Michael, let's talk a little bit about what might happen next here, because there is this probate issue that needs to still play out. It can be very complicated. There's a 1-year-old child involved here. And then there's also the potential, if Fitzsimmons chooses, to pursue some kind of civil action. What do you expect happens next?
Well, a lot more litigation. As you point out, Glenn, the probate court case will go on for years. I do expect at some point, assuming that she gets any mental health treatment that she needs, that there will be a reunification between mom and the child. The probate court is not interested in severing those bonds generally, so there will be attempts to try and restore that relationship, probably sooner rather than later. And there'll be a more thorough examination of all of those issues with respect to whether the restraining order was truly needed, whether some of those issues were fabricated for tactical advantage and the like. They've got a long time where they're going to be fighting in probate court unless they are able to resolve their differences sooner rather than later. From the civil standpoint, there's almost no doubt that there'll at least be threats of a suit against the North Andover police officers involved, as well as the department itself. Maybe that can be resolved short of this, but they're still going to argue the similar types of things that we saw here, is that there was no imminent threat to the North Andover police officer, that you didn't need to use deadly force, and that there are constitutional violations that have been committed upon her that she would expect to be compensated for. So I think you'll still see those arguments raised, and it may well end up in litigation if they're unable to resolve those differences.
Michael, the judge said that he found both sides credible. In other words, he believed that each side, Officer Noonan and Kellsey Fitzsimmons, both believed in those moments their recollection of what happened. Given that fact, and again, they found them both credible, is there anything the Commonwealth could have done, short of having body cameras, which we know they didn't have, is there anything they could have done that you think could have swayed this in their favor?
Yeah, I mean, and you're right. You try the case you have. So we don't have body cameras. You know, there could have been a little more evidence with respect to how that gun moved from where she took it out of the safe to her head. You might have wanted to slow that all down and have her explain in detail how it happened. In some ways, it seems almost impossible to be able to move the gun from your side to your head without that arm coming forward in some ways. So I think there may have been a closer examination of that evidence with respect to how that occurred. I also think the defendant, now they've won, so they likely don't have regrets, but there could have been better evidence that would support the mental health issues, the sectioning by the North Andover police. Obviously, with the not guilty verdict, they don't have any of the similar regrets, but I do think the prosecution probably has some that they believe they could have tried a tighter case. But at the end of the day, it's not the fault of the district attorney's office or the law enforcement involved. The burden of proof in a criminal case, as we've said multiple times, is extraordinarily high. And for good reason. We don't want innocent people to be put in jail. So in part, you had a he said, she said, as we've said from the outset. Those are incredibly difficult cases to win. You are always looking for support from others who don't have involvement in the case themselves, because they would be disinterested and less biased when you look at their testimony.
And Michael, maybe there is an elephant in the room that we should address. It's an unanswered question, but let's talk about it. What if Kellsey Fitzsimmons wants to be a police officer again?
60
it would seem to me that she has a strong claim. She hasn't worked at the North Andover Police Department since February of 2025, when she had her son. She was attempting to come back, and only a few days before she was to be reinstated, this incident happened on June 30th, 2025. So if she decides she wants to resume her career, does she have a strong case?
She has a case. I don't know how strong it'll ultimately be. The Civil Service Commission may have to examine that as well. But you also, as you point out, you have some significant issues with respect to how this went down and whether, in fact, under the circumstances, when she gets sufficient mental health treatment and she's able to, again, be a trusted law enforcement officer, whether she could continue that career. That's all right now debatable issues. So it would not surprise me. She testified that this was a lifelong passion of hers, that this is what she wants to do. The problem is there a department willing to look past what is a self-confessed acknowledgement that she intended to use her own firearm to take her life? And that's a hurdle to come forward with.
Since she was found not guilty, I want to just move on to something about cost of all of this. She spent 53 days in the hospital, collapsed lung, and all sorts of other health issues. She spent more than 3 months in jail. She has a team of lawyers, one of them being Martha Coakley sitting there. That can't be inexpensive. Is there anything she can do about the costs associated with what happened that day and what followed? Because it's substantial.
It is, and that will be what follows from the civil suit with respect to her argument that they had no right to use deadly force. But again, you have to look at the evidence and the information that came in this case. By her own testimony, she acknowledged that if a police officer saw her go for the gun, that she knew there'd be shooting. So she has contributed to her own injuries in a significant way here, as she has acknowledged. So that's going to lessen the argument that there's any liability anywhere else. So again, what you have is a very hotly contested liability issue. Damages are no doubt quite extensive, both for, not just from your compensatory damages for medical bills and the like, but think of the pain and the suffering and the loss of reputation, the loss of her job. You're talking about incredibly high expenses and likely damages if she can establish liability. But that's a long ways away. She doesn't have any right, in essence, to tell the state that they should compensate her because there was no basis to bring these charges, no basis whatsoever to shoot her. That's going to be a high hurdle to establish from the standpoint of liability based on her own testimony at this hearing.
All right, Michael, this is a rare situation, of course, where the defendant took the stand in their own defense. And I know from talking to you, it is rare that a defense team will allow their client to get on the stand and tell their story. In the end, that's what they decided to do in this case. Do you believe it is a big reason they won the case?
Yeah, and it's not us not lawyers allowing the client. Ultimately, at the end of the day, it's the client who chooses whether to represent and tell their own story and tell their truth on the stand. We give advice, and a lot of times that advice is you do not want to take the stand. But oftentimes, because they're carrying a lot of baggage from prior convictions, or as Margot pointed out last night, they have a lot of inconsistent stories, inconsistent statements, and now they're going to be impeached with those statements. You know, the fact is her hospitalization and a long time for recovery, and ultimately then because of that time having counsel who has clearly indicated to her not to say another word, you don't have all those prior statements. So you had an unusual set of situations here where the fact is it was to her advantage to testify just based on, you know, what you normally see as obstacles. And the other part of that is look at her testimony, listen to it. She was a very compelling witness. She was strong. She answered the questions. She wasn't evasive. And I think that's ultimately why the judge found her credible. The fact is that she could have done fatal damage to her case had she not held up on direct and cross-examination, and she did well enough that the court found her credible, so she saved herself from a felony conviction and any potential period of incarceration.
Michael, you point that out, and now you have to wonder what the verdict would have been if she didn't take the stand. Because you know, if you have two sides of the story, both are credible, I think that must have helped in making the decision. If you hadn't heard from her, I don't know how he would do that.
Yeah, excellent point. I think you're absolutely right. If all we have is the police officer's version and Officer Noonan is found to be credible and there is no alternative version of the events, then you can't beat someone with
I think
no
that's
one.
enough of
So
this
the
game.
fact is, I think she absolutely made the right choice. Again, in hindsight, but again, my understanding would be the attorneys for the defense prepared her
My
well
ass is
for
jump off stream. We've been on
cross-examination.
for
No
5
good attorney
hours.
allows their client to go on the stand, or allows any witness really to go on the stand without adequately preparing them for the direct and the cross-examination.
All right, Michael, this case, although it only started on Monday, had 98 exhibits, 11 witnesses, and the judge, when he came out to read his verdict from the bench, described this as an emotionally charged case. And as JC mentioned, he said it was exhausting, one of the hardest things he's had to do as a judge. And then in the end, after rendering his verdict of not guilty to Kellsey Fitzsimmons, a 29-year-old
appreciate everybody
former
that tapped
police
in on the
officer,
Rumble to
he did make
YouTube,
sort of
Twitch,
the
all y'all,
community
man.
comment
Good
about body
looking
cameras
out.
and how it
Hit
might
the
have
comments,
been a
hit the like,
deciding
hit the
factor in
subscribe.
this case,
Hit the
had that
subscribe
kind of
on
evidence been
YouTube.
available.
He also made a point, Michael, of
We back to doing
thanking
more content daily.
officers in
We're gonna try
general
to
for
at
their
least stay in the
service,
loop.
not to disparage officers in general for
You
the
smell me?
actions, and that they did the best they could in this case in a rapidly deteriorating situation. It seems like he's already preparing for what could be fallout, and that's just especially online, the judgment that comes in cases like this.
Yeah, I agree with both sentiments. The fact is, I'd be a lousy police officer because
AMD
I would be very
Ryzen
prone
9
to
90
use my gun to
9950
protect myself. So it's a
X3D2
horribly
dual
difficult
edition.
job. And we do, and I think the judge was right to thank all of the folks in law enforcement that protect us and that we can safely from our homes criticize. But I do think the time has come, as Glenn points out, that the body cameras now are going to be an issue in every trial moving forward, because just like DNA and all the forensic evidence that we saw grow in common usage over the years, juries are now looking for that, and they're going to hold it against the law enforcement if there aren't body camera images and recordings of the events in question. So
I will hold it against them too, because what y'all got to hide.
yes, there's an expense, but there's an expense with
Fuck y'all
everything.
got to hide.
And the cities and towns and the state are going to have to find a way to do this so that it's a reasonable cost to make sure both that we're safe and also that individuals' rights are protected in that process.
All right, Michael, it's just past 2:30 in the afternoon here. You're looking at a live picture outside Essex Superior Court. We expect Kellsey Fitzsimmons, who was just acquitted in this assault trial, to come out of those doors and address the media. I'll be very interested to hear what she has to say after the ordeal.
Let's jump to that. Respectfully.
Listen in as we begin with her attorney, Mr. Bradle.
It's just another day at the office today. Just want to say that we want to thank so many people. We want to thank Kellsey and her family for having faith in us. We, meaning Martha and I, want to thank so many people that Kellsey and her family had faith in us. And, we had a very tough playing field for a long time. And we also want to thank Judge Karp, who did a great job and was a gentleman and treated us fairly and with justice. And that's all we ever asked for. And we finally got it, so we're relieved. And but other than thanking everybody, I just want to hand it over to Martha, and she's going to have some words for everybody first.
Yeah, so thanks, Tim. This is not only the right result, it's a righteous result today. It's been a long odyssey for those of you who followed this, and we started off in this case, understanding, as we all do, and as the judge said, policing is a tough job. Being a mom is a tough job. And on June 30th, Kellsey had to do both. She's trying to be a mom. She's trying to get back to work. And then her world fell apart. And unfortunately on that day, as she said to the judge, and you heard in court, she had to deal with all that. And unfortunately, what happened in that bedroom started a chain of events with a narrative that they never diverged from. They never asked her about it. They rushed to judgment. And that case took on a life of its own, which unfortunately interfered with her life for an unnecessary and difficult time. I think Tim and I have known from the beginning that that wasn't fair, that the charges probably weren't fair, and that we were going to deal with the system, and we were going to take this to trial, and as Kellsey has said, without fail, she just wanted the truth to come out. She was able to do that when she testified in this case, and again, we're grateful for the judge's work. We're happy with this decision, and it's the right decision, as we said. She was always innocent until proven guilty. The Commonwealth did not meet their burden of proof, and she is innocent today.
Kellsey, what was it like to hear that word, not guilty? To hear the judge say not guilty this afternoon? You sat there, you were on the stand yesterday telling your story. Share with us what that was like.
So, I got shot. I went to jail for 103 days. I haven't seen my son. I had to sell my home that I worked very hard for. So this is my first breath of fresh air, and I feel like I can breathe again. However, my fight is not over. I have a son that I need to reunite with, and that's where we are right now.
Can you talk to us about Keaton? What's next for you? And
Respect.
how this verdict might help you reconnect with him?
I won't get into that, but I will say I am really excited to see my son again.
Do you have any plans to hire a personal injury attorney or have a personal injury attorney representing you?
I will also not get into that, but
yeah, today we're celebrating this verdict.
Yeah,
and that's
I'm
what we're
focusing on today.
One day at a time.
And I also would just like to thank everybody who stood outside each and every day, supported me, believed me before I got to tell my story, because it wasn't 9 months later until I got to tell the truth. And that was a long 9 months. And through those 9 months, you guys knew the truth. You guys believed in me, and thank you for that.
Kelsey, what's the message? Kelsey, what's the message to others that are in a position like yours after what happened today with the not guilty verdict? What would you tell other people?
Don't stop fighting for what's right, and when you know you didn't do something wrong, keep fighting for that.
Kelsey, do you want to be a police officer again?
I won't comment on that either. I don't know what my career goals are at the moment.
What have the last 9 months been like for you as a person, as a mother, as a defendant?
There's not a word. If you want an image of it, picture me on a mat in a jail cell crying for my son day after day after day after day. There's not a word for that, but that is what happened to me.
Kelsey, do you feel like you're owed something now, considering that you've been found not guilty? All of this stuff has happened to you.
I'm going to leave that one to you.
Leave that one to the lawyers, Sarah.
Hey, Kelsey was going to tell us why the decision, which of course we would not have gotten with the jury verdict. So it's helpful to have that as well.
Kelsey, you talked about how this is a just verdict, in your opinion. Were you surprised these charges were brought in the first place, and why do you think they were?
So I'm just going to repeat what I said earlier to that question. A set of things got set into motion on June 30th that then followed a narrative starting that night in that room that never really got challenged, that never really got investigated with any investigation of her, that never got tested in any way, but the presumption was that she was a defendant in this case. And so that's unfortunate because she couldn't talk for a while. She's being held for a while. She never got a chance really to tell her story. Ordinarily the system shouldn't work that way, but both Attorney Bradel and I have been on both sides of the system. We know how it works, and sometimes when it doesn't work well and it works slowly, that's unfortunately what happened in this case. And we fought every way with Kellsey to make sure that justice was done. It took longer than it should have, we think. It was more painful than it should have been, but look, we got the right result today, and we are happy with that.
Kelsey, what's the next thing you want to do now that you're not guilty?
Guys, hold on. Let's give these guys over here a
Starting
chance.
today, all of your bail restrictions are lifted,
but there's a lot of changes that are going to take place today. You have a lot more freedom than you had. How do you plan to start that journey of freedom?
I want to go for a walk with my dog. I can't wait to take him for a run. I haven't been able to do that, but that's our thing, is going for a run. So.
And don't forget, she couldn't do that.
Right.
She had to sit in her house. That was her best case scenario, that she was a prisoner in her own home. And then her worst case scenario at the outset of this case, and like Martha said, this was such a bumpy road, a long, bumpy road that never should have happened.
Blink and get more with new 2K Plus Smart Security. With Blink 2K Plus, get set up in minutes to see every detail in crisp 2K video. Get noise cancellation for clearer two-way talk.
Hey!
Oh, hey, perfect timing.
Get wireless power for up to 2 years of battery life. Plus, with smart detection, you always know who's there. Plug in or battery powered. Get.
This case started out as
All
a
right, gang.
circus.
Respect.
And we are so grateful
Respect.
to end up in Lawrence in front of Judge Karp, who, like I said,
Respect. This is something I don't think I've ever streamed before. I don't really even know how to play Fortnite, keep it real. Don't speak. My daughter be on here, keep it real. My daughter be on here fucking it up. I actually gotta buy her some more of these, not these, I gotta buy a Robux. Yeah, what movie is they from? How do you play? Oh. Gotta be juice, bro. Creator, Epic. What does that mean? Oh, Epic is the creator of Battle Royale. Oh, my final word is I might just do yeah, I'm about to just jump off stream for a minute. Let my shit breathe. My internet is messing up. It's showing on here. Oh my god, bro. This shit is unplayable. It's all because of the internet. Literally all because of the internet. I can't even play this shit, bro. My internet fucking is. Chat, I'll jump back on later. Because as it's showing me, the internet is fucking killing me. So I'm gonna let the brother. I'm gonna let this do its thing. I'm gonna let the internet get a good reboot on itself. And I will be back. Probably a couple hours. I will be back, chat. Appreciate everybody for tapping. It's your boy AC the 315. You know, we live. Appreciate that shit. And we shall be back a little later.